right here. I do not have it in the files books.
Okay, so you want to proceed and make your record?
Yes, Judge, I would ask that there was one, a sample one from the state. Judge, I believe it does also go to our theory of defense that Mr. Blandino was mistaken as his fact that he was in a legitimate negotiation. That this was, in his mind, wrongly so, the fact that this was not a negotiation that he could engage in. And I think that goes to the specific intent, which would be required to.
So guys, how you doing? Sorry, I got sidetracked at
extortion
on the job, and now I'm back. Looks like we're into getting ready for jury instructions.
Legitimate legal negotiation.
Any response?
So, hello.
Yeah, Your Honor.
Yeah,
No
if he kept on testifying, I apologize. I didn't get to see any of it.
We did discuss it in argument with that. There was no indication that I saw that in the evidence that there's any specific mistake of fact, and there was none that was argued by the defense as to what exists, right? Any mistake of fact that would call for this court to bring in a mistake of fact instruction.
Okay, and I indicated I would not be giving a mistake in fact instruction. Mr. Bateman, any other instructions you would like to propose?
No, Your Honor.
And no objection to the jury form, correct?
Correct.
Okay, before we bring the jury back in, is the defense going to rest?
Yes, we have.
Okay, I just
So-
want to make sure,
Yes.
and then.
Did he testify earlier, or did they really just get back to it? I think that the attorney, the prosecutor's argument about,
lined up in rebuttal,
being mistaken is true. Like, you have to have a genuine belief, but he doesn't have that.
It's not unavailable due to emergency at work. Given everything,
So,
we're not going to ask to continue. We're going to ask it to just go forward.
Okay, so we'll bring them in and we'll instruct them on the law, and both sides can speak to the jury in their closing arguments.
so how was your guys' afternoon? Mine is,
Okay,
mine was rather eventful. I like this judge. I like her big hair. I bet she uses a lot of product. I also cannot figure out how to get a feed that's not our data judges. So I'm sorry, this is what it is. A lot of times you can make the jury instructions helpful, but I mean, this guy's going to be toast. I don't think the jury's going to find for him regardless. Unless the jury's going to say, I mean, I think you might be able to get a jury to say, look, this guy was just a nutter, leave him alone. Which, it could happen.
Thank you, everyone, for being seated.
does the state stipulate to the presence of the
Matthew, what do you
jury
mean some of the arguments have been awesome?
the defense?
Yes, Your Honor.
All right, Mr. Dickerson, does the state have any witnesses in rebuttal?
No, Your Honor, we're ready to proceed to close.
Okay, thank you. At this time, ladies and gentlemen, you have heard all of the evidence that will be introduced in this
Oh,
trial.
this part's gonna be
Now,
jury
my duty as
instructions.
the
Gonna
judge,
suck.
instructed in the law. You will all be given a copy of the
I know you
jury
guys don't like
instructions.
listening
I
to them,
have
but imagine when I have to
read
hear them
them
all
to
the
you.
time.
You can follow along. You will
And now I'm
have
doing it
these
for fun.
instructions to
Makes
take
me
back
feel like
with
I'm a
you
sadist.
when you are excused to deliberate upon your verdict. It is now my duty as judge to instruct you in the law that applies this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be, or would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Number two, if in these instructions any rule, direction, ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction, ignore the others, but you are to consider all.
But that's
the
what juries do.
instructions
They
as a whole
focus
and
on
regard
whatever they
each in
want.
the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number three, an indictment is but a formal method of accusing a person of crime. It is not of itself any evidence of his guilt. In this case, it is charged an amended indictment that on or between April 8, 2019 and May 21st, 2019, the defendant committed the offenses of extortion and impersonation of an officer. Count one, extortion, did done in there willfully, unlawfully, feloniously, and with the intent to extort or gain any money or other property and or to influence the action of any public officer, whether or not the purpose is
Wait, wouldn't
accomplished
feloniously and
directly
unlawfully be
or
pretty much the same
indirectly
thing?
to
Because
accuse any person of
I don't know. I
crime
mean,
and
just it seems
or
weird to me.
to expose or impute to any person any
To tell me I'm
deformity
being
or
felonious
disgrace
and
to wit,
unlawful.
by making a demand to Michael Federico, a Las Vegas Municipal Court Judge Pro Tem, for $25 and or enrollment in the ethics, fairness, and security in your courtroom and community class, or in the alternative, pay $500 to the Clark County Library and or provide defendant an apology, including in writing and or in public. And if Michael Federico did not complete this class, pay this money and or provide said apology, defendant would file complaints and or allegations against Michael Federico with the Commission on Judicial Discipline and or would file a criminal complaint with the FBI accusing Michael Federico with a misdemeanor crime under 18 USC 242 and or would send documentation of Michael Federico's alleged misconduct to the law firm of Olson, Cannon, Gormley, Angelo, and Staberski, where Michael Federico was employed. Count two, impersonation of an officer.
Hi, guys.
Did willfully, unlawfully, and falsely impersonate a public officer, civil or military, or a police officer or a private individual, having special authority by law to perform an act affecting the rights or interests of another, to wit, an
Yeah,
investigator.
did this guy say he was
for
like the
state
judge
and Nevada
police or
Commission
something?
on Judicial Discipline, and in such assumed character did an act purporting to be official whereby another is injured or defrauded, identifying himself verbally and or in writing to one or more persons, including Michael Federico and or P.
I went to
Marwitz,
college
as
with
an
a guy named
unpaid
Matt
and/or
Federico. I
voluntary
wonder if they're
investigator
related.
for the State of Nevada Commission on Judicial Discipline. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more.
I like her though.
offenses
She speed
charged.
reads.
Each charge and the evidence.
Judge Levitt
pertaining
is
to it
speed
should be
running this
considered
shit,
separately.
guys.
The fact you may find the defendant guilty or not guilty.
Also, no offense, but I'm gonna play squad while she reads instructions because this is boring.
There must exist a union or joint operation of an act forbidden by law and intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge.
Yes.
And the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 5, the defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt or the element of the crime charged, and that the defendant is the person who committed the offense. A reasonable
Guys, I
doubt
was gonna
is
ask, is
based
the echo okay
on
today, or
reason.
have you
It's not
heard it
mere
at all?
possible doubt, but it's such a doubt as what governor
You
controls
smart
a
ass.
person in more weighty affairs of life. The minds of the jurors after the entire comparison and consideration of all the evidence are in such a condition that they can say they feel an abiding.
But yes, I am
conviction
at
of
home
truth
if you
of
haven't
charge,
noticed.
there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable
Impressionist
doubt as to the guilt of
artist,
the
it's about a
defendant, he is
sovereign
entitled
citizen doing
to a
sovereign
verdict of
citizen
not
shit.
guilty.
He tried
Number
to
6, you are here to
tell a
determine
judge,
the
like, look, if you
evidence
agree to what I'm
as proof
proposing,
from
I'll
the
let this
evidence in
go,
the case. You are
or
not
I'll have
called
to take
upon to
action.
return a verdict
So they charge
as
him with
to any other
extortion. It sounds like
person.
a
So if the
traffic
evidence
ticket.
in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Number 7, the evidence that you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is the
Direct and
testimony of a
circumcision
person claiming to
evidence.
have personal
What?
knowledge of the
Huh?
commission
Ooh,
of a
what?
crime
Ooh.
which has been
For that.
charged, such as an eyewitness. Circumstantial evidence is the proof of the chain of facts and circumstances
Oh.
which tend to show whether the defendant is
God, this is
guilty
so
or not
weird
guilty.
looking at a
The
trial that's
law
going
makes
on
no
so late in the
distinction
day
between the
for
weight to be
me.
given either direct or circumstantial evidence.
Matthew's like,
Therefore, all of the evidence in
it's
the
almost
case,
like
including
sunrise where he's at.
circumstantial evidence,
I know it's not
should
that
be
bad, but
considered by you
it's
in
getting
arriving
late
at
there,
your
and this is
verdict.
only going to go for a
Statements,
while.
arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true in the insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen
Hold
or
on,
heard
guys.
outside
Hold
the
on.
courtroom is not
I gotta
evidence
fix this real quick.
and must also be
Yeah.
disregarded. Number 8, the
Jesus.
credibility or believability
Guys, chill.
of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the manner to which he testified, the reasonableness of his statements, and the strength or weakness of his recollection. You believe a witness.
All right, guys,
has
I'll
lied
be
about
right back.
any
Apparently, I have to feed the
fact
savages.
You may disregard the entire testimony of that witness or any portion of his testimony, which is approved by other evidence. Number 9, the defendant's testimony in court is to be treated the same as testimony of any other witness and may be considered for all purposes. Number 10, it is not necessary to call as witnesses all persons who may have been present
My
at
dog's
any
barking
of
at
the
your
events
dog.
disclosed.
What am I
and
cheering
the
about? No, it's
evidence
barking.
may
Let's go.
appear
Bark,
to
bark,
have
bark.
some knowledge of
Bark.
these events or to
Bark.
produce all
Bark.
objects or documents mentioned
Bark.
or suggested in the
All
evidence.
right.
Number 11, a witness
Let's go, guys.
who has special knowledge, skill, experience, training, or education in a particular science, professional occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Number 12, a person who, number 1, with the intent to A, extort or gain any money or other property, or B, influence the action of any public officer, whether or not the purpose is accomplished, threatens directly or indirectly to accuse any person of a crime or to expose or impute to any person any deformity or disgrace, is guilty of extortion. Number 13, a specific intent, as the term implies, means more than the general intent to commit the act. To establish specific intent, the state must prove that the defendant knowingly did the act which the law forbids. An act is knowingly done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. The intention may be inferred from the defendant's conduct in all other circumstances. You are instructed that extortion is a specific intent crime. Number 14, every person who shall falsely personate a public officer, civil or military, or a police officer or a private individual having special authority by law to perform an act affecting the rights or interests of another and in such assumed character shall do any act purporting to be official whereby another is injured or defrauded shall be guilty of impersonation of an officer. Number 15, officer and public officer includes, number 1, all officers, members, and employees of the state of Nevada, any political subdivision of the state of Nevada, any other special district, public corporation, or quasi-public corporation of the state of Nevada, and any agency, board, or commission established by this state or any of its
Oh, we're still
political
going.
subdivisions.
Yay.
All persons exercising or assuming to exercise any of the powers or functions of a public officer. Number 16, Nevada law provides for the appointment of alternate municipal judges, which are known as municipal judges pro tempore or municipal judges pro tem. Municipal judges pro tem possess the same authority as elected municipal judges during their appointment, including jurisdiction over misdemeanor criminal cases in the city of Las Vegas. The city of Las Vegas is a political subdivision of the state of Nevada. Municipal judges pro tem have the power to preserve and enforce order in their immediate presence and in the proceedings before it, as well as to compel obedience
I wonder if
to
he's
the
going to make an
lawful
argument about
orders
the fringe and the
to lawful
flags.
orders of another judge
It'll be interesting.
out of court in an action or proceeding pending therein. Number 17, the State of Nevada Commission on Judicial Discipline was established by the Constitution of the State of Nevada. The
What is
Constitution of the
government?
State of Nevada provides a
Says
commission
the
on
sovereign
judicial
citizen. What
discipline,
is time?
the
Why are we
authority to
here?
censure, retire, remove, and discipline any Nevada judge, including any municipal judge. The Constitution of the State of Nevada further provides a commission on judicial discipline authority to hold hearings, summons witnesses to appear and testify under oath, compel the production of evidence, and grant immunity from prosecution or punishment in order to compel the giving of testimony under oath and the production of evidence. Nevada law provides the Commission on Judicial Discipline authority to employ and/or contract with investigators. Nevada law requires the Commission on Judicial Discipline to assign or appoint an investigator to conduct an investigation when it finds a complaint alleges objectively verifiable evidence from which a reasonable inference could be drawn that a judge committed misconduct or is incapacitated. Such an investigation must be conducted in accordance with the Commission on Judicial Discipline procedural rules. Commission on Judicial Discipline investigators have legal authority to
Oh, I
compel
got
by
owned.
subpoena
So I'll stop.
the attendance of witnesses and the production of evidence. At the conclusion
I'm
of
done
the
playing.
investigation, the investigator
Oh,
is
Andrea,
required
holy
to
shit, we haven't seen you
prepare
in
a
a while.
written report of the investigation for review by the Commission on Judicial Discipline. Number 18, a threat or to
Miss,
threaten
what happens
another
at 6
person
p.m. on
is a
Sunday?
serious expression of the speaker's purpose or intention to harm the person, property, or rights of another by commission of an unlawful act. A threat can include almost any kind of an expression of intent by the speaker to do an act against another person, including through
Now,
oral
I mean, I'm going to
and/or
say,
written words. The speaker need not actually intend to carry out the threat. Number 19, a
it looks like
crime
your picture was like
is an act or
photoshopped.
omission forbidden by
Doesn't it,
law and
to me?
punishable
Or
upon
is that just
conviction
me?
by death, imprisonment,
Not making
fine,
fun of her. It just
or
looked like the
other
picture
penal
was like
discipline.
messing with.
Title 18, Section 242 of the United States Code, 18 U.S.C. 242 is a federal criminal statute that provides for a misdemeanor criminal punishment, including imprisonment for not more than a year and a fine. Number 20, extort means influencing another person's action through withholding a disclosure of information. Disgrace means to humiliate or cause loss of favor or standing. Number 22, a person can be injured physically, mentally, or financially, which includes suffering damage to their property. Number 23, ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and when accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be crime, it is no defense that he did not know that his act was unlawful or that he believed it to be lawful. Number 24, a defendant's religious beliefs are neither a defense nor an excuse to the crimes of extortion or impersonation of a public officer. The right to engage in actions or conduct prompted by religious beliefs or principles remains subject to criminal laws enacted by the state of Nevada. Number 25, entrapment is an affirmative defense. The defendant bears a burden of producing evidence of governmental instigation. Once the defendant puts forth evidence of governmental instigation, the state bears a burden of proving beyond a reasonable doubt that the defendant was predisposed to commit the crime. The basic question in determining if the defendant was predisposed to commit the crime is whether the defendant was ready and willing to commit the crime if an opportunity should be presented. 5 factors that are helpful in determining the defendant's predisposition. Number 1, the character of the defendant, who first suggested the criminal activity. Number 3, whether the defendant engaged in the activity for profit. Number 4, whether the defendant demonstrated reluctance. And number 5, the nature of the government's inducement. While these factors are not exhaustive, it is worth noting that the most important factor is whether the defendant
These instructions are
demonstrated
exhaustive
reluctance, which
and
was
exhausting.
overcome by the government's inducement. Raising an entrapment defense places the defendant's character directly in issue. Number 26.
Oh, you're kidding
Although
me?
you are to consider all
Are
the
you
evidence
entrapment?
case, reaching a verdict must bring to the consideration of the uninterpreted common sense and judgment as reasonable men and women.
What a
Thus, you are not
moron.
limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the
That's gotta
light
get
of
somebody
common
trapped him.
experience. Keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 27, while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of liability in arriving at your verdict. Number 28, in your deliberation, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of whether the state of Nevada has met its burden of proof.
Oh, this
as
jury's
to the
gonna be out less than an hour.
29. During your deliberations, you are not to communicate.
I guarantee
with
those
anyone
people are
in any
thinking,
manner
wait, we had to deal with
regarding
this
the facts
shit?
and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You are not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You're further admonished not to conduct any investigation, test a theory of the case, recreate any aspect of the case, or in any other manner investigate or learn about the case on your own. Number 30, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation and will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence.
Will there be a
These
jury
written
police
instructions and
officer
forms of verdict prepared for your convenience.
along with
Your
them?
verdict must be
Probably cries the
unanimous.
crazy man.
As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 31, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your mind the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind, it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. And at this time, the state of Nevada may open and close the arguments. Thank you.
Here, oh wow, we're jumping right to it. Here we go.
Good afternoon, ladies and gentlemen. So thank you so much for being here for the last 10 days. I know it has been a little longer than everyone expected, but we appreciate you being here and listening to all the evidence. So as Mr. Dickerson stated when he made his opening statement,
Funny name.
this case is
Dickerson.
about the rule of law.
Hee
This
hee.
case is about the judicial process and the authority the courts have over individuals. However, this case is also the rule of law against the rule of Blandino. Mr. Blandino wants to subvert the rule of law to accommodate his own desire for control and power over the courts. I know you guys have listened to this evidence over and over again, so you're familiar with it. You will have that back in the deliberation room with you. But let's go through this timeline once more. So on August 8th of 2018, Mr. Blandino appears in municipal court in front of Judge Pro Tempore Michael Federico for a variety of traffic tickets. At the conclusion of the bench trial, Mr. Federico finds Mr. Blandino guilty of the traffic offenses. Mr. Blandino testified that after that, he did an appeal, as is his right. He appealed the decision.
I'll look over my glasses like she is. Like,
The district court ultimately found against him and dismissed his appeal. Now, 8 months after that, 8 months after this traffic trial, Mr. Blandino went to Mr. Federico's law office, the law office in which Mr. Federico worked in his capacity as a private citizen, as a private attorney, and attempted to talk to Mr. Federico. Now, again, we've had August 28th, we've had the month of September.
That's a little
October,
sketchy,
November,
what he did
December,
going there.
January 2019, February 2019, March 2019, and now we're on the 8th month after this traffic trial. And this, oh, am I? Oh, it did. It's all good.
It's all good. Like, who are you to say what's good, prosecutor?
So 8 months after the conclusion of this traffic trial, wherein Mr. Blandino was found guilty, he shows up at the law office of Mr. Federico, and he tries to talk to Mr. Federico. You heard from Ashley Williams, a receptionist that day, and she indicated that Mr. Blandino was very insistent on trying to find Mr. Federico. She testified that Mr. Blandino asked for a piece of paper in order to write a letter to Mr. Federico. However, she also testified that Mr. Blandino stayed in the reception in the lobby area for about 20 minutes writing this essentially one-page letter. All right.
He didn't come back
So-
to it. The lunatic.
Mr. Blandino stayed in this lobby area for approximately 20 minutes, writing this short one-page letter while asking Ms. Williams probing questions about Mr. Federico, about whether she knew he was a judge, about whether she'd worked on any cases with him before, basically trying to pull information from Ms. Williams about Mr. Federico. Mr. Federico sat up here on the stand and told you that he was made aware that Mr. Blandino had walked in on April 8th and recognized the voice from this traffic trial 8 months prior. He testified that he went up and had an overview over the lobby area and could hear Mr. Blandino asking questions and basically hanging around until he eventually left. Now, you read that letter. In that letter, Mr. Blandino says, "I am ready to begin filing my complaint against you. Please reach out to me so we can settle matters." So the next day, Mr. Federico, concerned about the fact that a defendant from a traffic trial in which he was found guilty appeared at his law office, Mr. Federico goes and files a report with Metro. 2 weeks after that, Mr. Blandino intrudes upon Mr. Federico's courtroom, where he is sitting as a judge pro tempore once again, and walks in. Now, again, Judge Federico, who has not seen the defendant in 8 months, who has already filed a complaint and a report against Mr. Blandino.
Yeah.
Judge Federico sees Mr. Blandino and asks him to leave the courtroom. Now, yes, was he severe when he told Mr. Blandino to leave? Absolutely. But Mr. Federico sat up there and told you that he was very concerned and that basically he lost the power of speech due to his concern about the fact that twice in the past 3 weeks, Mr. Blandino has basically appeared where Mr. Federico was. Later that day, Mr. Blandino, extremely upset about the court proceeding earlier that day, once again, shows up to Mr. Federico's office in 9950 West Cheyenne, all the way across the city. And he shows up there, and this time he had a pre-prepared letter telling Mr. Federico in no uncertain terms how upset he was about the treatment he received that morning, and told Mr. Federico that once again,
Matthew's just having a lot of
Mr. Federico mentioned
ADAs.
then, and he wants to settle matters, or he will be filing a complaint with the Nevada Commission for Judicial Discipline. April 29, 2019, you've heard testimony from Detective Mead, Marshall Marwitz, Mr. Federico, and Mr. Blandino about the fact that there was a call. Now, once Mr. Federico reported once again to law enforcement that Mr. Blandino had showed up in his courtroom and once again to his office on the 25th. Detective Mead, Marshal Marwitz, wanted to do some follow-up investigation. So they go to Mr. Federico's office, talk to Mr. Federico, and they decide to have Mr. Federico call the defendant in order to get additional information. And they want to know what Mr. Blandino means when he uses this term negotiate or settle.
Oops, sorry,
Because
sorry,
that term
sorry.
was used over and over again
Hit the wrong mouse
in the
button.
April 8th and the April 25th letters. So during this phone conversation, Mr. Federico starts off saying, you know, what will it take to get you out of my hair? And Mr. Blandino takes that opportunity to talk to Mr. Federico. Mr. Blandino told you, he has done this multiple times. He has sent letters to multiple judges, and this is the first time someone has called him back. And this was the moment that Mr. Blandino knew that he had some power here. So Mr. Blandino tells Mr. Federico, I want a public apology. Mr. Federico is like, is there anything else we need to be doing to settle this? Are there any other terms that you want out of this? What do you want in exchange? And Mr. Blandino says, I gotta think about it. I know at the very least, I want a public apology. So conversation ends there. 3 days later, Mr. Blandino sends a settlement demand to Mr. Federico. And again, you guys have seen that settlement demand. It is basically in exchange for Mr. Federico paying $25 for the jobs fee, in exchange for Mr. Federico making a written apology to Mr. Blandino, in exchange for Mr. Federico paying $500 to the Clark County Law Library, or in the alternative, paying for a $1,500 ethics class up in Reno by a certain date. Mr. Blandino would agree not to file a complaint with the Nevada Commission for Judicial Discipline for the incident that took place on April 25th of 2019. Mr. Blandino further asks and further demands in this settlement agreement that Mr. Federico, when he sits as a judge pro tempore, allow him free access to the courtroom at any time. When Mr. Blandino doesn't hear back from Mr. Federico, Mr. Blandino gets upset. Now, in this May 8th, 2019 letter, we have a couple, if you don't do this, then I will do this. We have the, if you don't get back to me about the settlement demand I made, I will file a complaint with the FBI under 18 U.S.C. 242, which is a criminal misdemeanor in federal court. So if you don't do this, I will do this. Moreover, Mr. Blandino states that, by the way, if you don't get back to me within another week, I think that your bosses need to know exactly what you did, and I think your bosses need to know that they are exposing themselves to disrepute by keeping you employed, essentially. So, 2 threats there. 1, to file a complaint, a criminal complaint with the FBI, and 2, well, let me tell your bosses how bad of a person and how bad of a judge you are. And finally, a week after that, Mr. Blandino follows through with that threat from May 8th and actually sends a
Chill,
letter
Greta, chill.
to the
Oh,
law
no.
firm of
Hey, Lucas.
Cannon, formerly Angulo and Seversky, who employ Mr. Federico. So there's our timeline. In every criminal case, the state has 2 things to prove. 1,
She's dragging this out,
But
though.
it's
She's
hard.
not a good
and
storyteller.
2, that the defendant committed a crime. Now, okay, ladies and gentlemen, this is not a whodunit, right? We all know who was involved in this case. Mr. Blandino himself admitted that he wrote every single one of those letters. He admitted he wrote every single one of those letters, made the statements in those letters, and he testified on the stand as to the actions that took place on August 28th, 2018, on April 8th, 2019, April 25th, 2019, May 2nd, May 3rd, May 8th, and May 16th of 2019. So this isn't a whodunit. Mr. Blandino committed the crimes that are charged. Now, The second thing that the state has to prove to you beyond reasonable doubt, and you have your beyond a reasonable doubt instruction, is that the defendant committed the crimes charged. So Mr. Blandino committed the crimes of extortion and impersonation of a public officer. We're going to break down those elements a little bit because the instructions that were provided to you as to what those crimes are a little lengthy. So what is extortion? Essentially, if you do X, then I won't do Y, or I will do Y unless you do X. Again, that May 8th letter, ladies and gentlemen, has that specific language. I will send a copy of all the relevant documents to OCG A&S unless I hear from you by May 15th of 2019. Ladies and gentlemen, that is textbook extortion. Here are the elements. So this is your instruction, and essentially a person who with the intent to extort, gain any money or other property or influence the actions of any public officers, whether or not the purpose is accomplished, threatens directly or indirectly to accuse any person of a crime or to expose or impute on any person any deformity or disgrace, is guilty of extortion. The elements I want you to focus on are the threat, whether direct or indirect, and the intent behind Mr. Blandino's statements to Mr. Federico. Again, it doesn't matter whether the intent is, it doesn't matter whether Mr. Blandino was actually paid that $25. It doesn't matter whether Mr. Blandino actually gets this apology from Mr. Federico. It doesn't matter if Mr. Federico doesn't pay the $500 to the Clark County Law Library. What matters is that these are the statements that were made. So what constitutes a threat? You have an instruction about that. You're going to have an instruction about pretty much everything. A threat is a serious expression of the speaker's purpose or intention to harm the person, property, or rights of another by commission of an unlawful act. A threat can include almost any kind of an expression of intent by the speaker to do an act against another person, including through oral and or written words. The speaker need not actually intend to carry out the threat, right? So a threat, you just need to intend to speak those words to another person for a specific purpose. In this case, the specific purpose that Mr. Blandino had, his intent for all of the crimes that we've charged, is he wants power and he wants control, right? He lost his traffic trial. He lost his appeal. The judges against whom he's filed complaints, the judges to whom he sends letters, basically ignore him. He testified to that. And Mr. Federico did not ignore him.
It's a very nice
Mr.
courtroom. I like it.
Federico gave him that idea that
The lack
hey,
of windows is really
I can get some power here. I can have a little control here. So Mr. Blandino can file as many complaints as he likes.
Melanie's
Mr.
talking a
Blandino
lot
can
about
file as
control.
many, reports to the FBI as he wants. That is not an unlawful act. He can do that. Paul Riley from the Nevada Commission of Judicial Discipline told you he is free to file complaints. That is not what the unlawful act is. However, making that complaint or report contingent on someone doing or not doing something, that is an unlawful act. If I know that someone committed a crime and I say, hey, you know, I know you did this, but if you pay me, you know, whether it's $10, $100, $1 million, doesn't matter. But I know you did this, so unless you pay me X, I'm going to report you. That, ladies and gentlemen, that's extortion. And it doesn't matter. Again, I understand that $25 is not $1 million. It's not $10,000, but $25 in the manner in which it was demanded from Mr. Federico, that is an unlawful act. Okay, extortion. What kind of threats are we talking about? We are talking about a threat to accuse a person of a crime or to expose or impute any disgrace upon another person. In this case, we have both. I talked about that May 8th, 2019 letter that Mr. Blandino sent to Mr. Federico. Now, that letter contains both of those. And I would note that you don't need to agree. All 12 of you don't need to agree that he threatened to accuse a person of a crime. 5 of you could say, hey, he threatened to accuse Federico of a crime, and the other 7 could agree that, he threatened to impute a disgrace on Mr. Federico. As long as all 12 of you agree that there was a threat, directly or indirectly, to do one of those 2 elements, we have Mr. Blandino guilty of extortion. So, May 8, 2019, I discussed this. Mr. Blandino tells Mr. Federico, by kicking me out of the courtroom, you violated important civil rights. In fact, you can be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 USC 242 for your action on April 25th of 2019. Ladies and gentlemen, that is threatening Mr. Federico and telling him that he is going to accuse Mr. Federico of a crime. Again, that next page. If we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench on April 25th, 2019. Granted, this would only be a misdemeanor. However, it may help others that come after me.
Digging through his sovereign citizen toolbox.
So there's your
There's got to be some
threat
UCC
to
arguments
accuse
in
someone
there.
of a crime, again. And same letter, May 8, 2019. Further, Mr. Blandino then, in that same letter, threatened to accuse Mr. Federico,
I didn't hear her specifically.
basically
What did she
threatened
say?
to impute disgrace, right? So he told Mr. Federico, like, I am going to tell your bosses that you committed ethical violations unless you actually have to sit down with me and discuss what I want. So I've come to realize that since you work within a partnership titled Olson, Cannon, Gormley, and Gulen Saversky, OCGANS, that I should give some notice to these individuals of the matters involved prior to filing with the NCJD or the FBI. The calculus for this is simple. Putting myself in the place of any one of these partners and everything else being equal, I would want to know that a person who worked with the firm and had a prominent webpage was not bringing any disrepute in any way to the firm or its name. Ladies and gentlemen, this could not be more clear. Mr. Blandino told Mr. Federico that, you know, I think that your bosses would like to know exactly what you did. And I think they would be very concerned to know that, you know, you could bring them disrepute. Essentially, Mr. Blandino, what he is doing here is not only imputing disgrace on Mr. Federico, but he is also threatening his livelihood,
Yes,
right? Because you're telling
they have to
my
agree
boss-
the threat is
you're telling
enough,
Mr.
not
Federico's
specifically which
boss
threat he did.
that Mr. Federico is a bad person, that he may have complaints filed against him, that he may bring bad publicity, essentially. With those words, Mr. Blandino is telling Mr. Federico, you better listen to me. You better take me seriously or I will do this. Unless you sit down with me, I am going to tell your bosses about this. So again, Mr. Blandino keeps going about how he's doing this for the greater good. He's really just, you know, he wants Mr. Federico's bosses to be aware of this because that's what his religious beliefs prompt him to do. That last line, therefore, consistent with my beliefs, I will send a copy of all the relevant documents to Olson, Cannon, Gormley, and Gulen Stabersky unless you get back to me by May 15th of 2019. Now, we've gone through those threats that constitute the elements of extortion. We have Mr. Blandino threatening Mr. Federico with federal crime, and we have Mr. Blandino threatening Mr. Federico with going to his bosses and assigning disgrace upon Mr. Federico's name to his bosses. Then we go into the intent. What was the intent behind those threats? For extortion to be met, you need to have Mr. Blandino's intent to be either to extort or gain money or other property, or influence the action of another officer. Now let's look at the specific language in these letters that Mr. Blandino has sent to Mr. Federico and the statements Mr. Blandino made on the stand. Let's look at his testimony. Mr. Blandino sat out there, we watched this Javs video of that traffic trial for a second time, and Mr. Blandino listed out every instance where he saw conduct that could, in and of itself, be the basis of a complaint to the Nevada Commission for Judicial Discipline. I believe Mr. Blandino, at the end of his testimony, told you, I counted at least 5 actionable offenses during that traffic trial. However, that traffic trial was August 28th of 2018. He did not report any of this behavior, any of these actionable behaviors for 8 months. Mr. Blandino instead did as is his right and appealed his conviction. He lost that appeal, and only then did Mr. Blandino decide, hey, you know, I'm going to take matters into my own hands here, and I'm going to make sure that I get a little power, I get a little control, and I get to tell Mr. Federico, Judge Federico, what's what. And Mr. Blandino told you that, hey, if at any time Mr. Federico had said, buzz off, make your complaint, I'd have stopped and filed my complaint. Ladies and gentlemen, I would submit to you that Mr. Federico ordering Mr. Blandino out of the courtroom on April 25th of 2019 was precisely that. That was Mr. Federico telling Mr. Blandino, you are not to come to my office, you are not to bother me, essentially. You are not to bother me in my capacity as a private citizen. But what did Mr. Blandino do? Later that very same day, he went back to Mr. Federico's office, ladies and gentlemen. He went back because at that point he knew that he got under Mr. Federico's skin. He knew that he had gotten under a judge's skin, and he knew that he had to keep going. He wants that control and he wants that power. Now, let's talk about, what the intent was, what those terms were that the defendant wanted from Mr. Federico. He wanted money or property. Again, it could be $1 million, it could be the $25 for the jest. He wanted money in exchange for not filing that criminal complaint. But let's look at his statement. April 8, 2019. Essentially, if you don't agree to settle, I will file a complaint. I am ready to begin filing my complaint against you. I am required by my religious beliefs and practices to give you an opportunity to negotiate a settlement. Please let me know within the next 10 days. My last 2 complaints resulted in letters of caution to the judges. Please don't take this matter lightly. Now, ladies and gentlemen, first of all, speaking about those letters of caution, Mr. Darley testified that letters of caution are confidential, and nothing in any of those letters that were presented to you says the word it's a letter of caution. I know Mr. Blandino believes there is, or testified that there was some secret code within the language of each of these letters that made him believe that they were letters of caution, but you don't have any evidence that these were letters of caution. But I would note that Mr. Blandino does believe that those were letters of caution. He attached them.
Blandino, please. Sorry, go ahead.
Sorry.
Mr. Blandino attached those letters that he believed were proof that he could get a judge in trouble, essentially, to the letter he sent to Mr. Federico. And he attached those on April 8th, 2019, the very first time he made contact with Mr. Federico. Actually, I apologize. He attached those letters on the April 25th letter. He mentions them only in the April 8th letter. Essentially, the meaning behind the April 8th handwritten letter is, hey, if you don't want to be in the same position of those judges and receive a letter of caution, you need to get back to me. April 25th, 2019. This letter could essentially be titled, talk to me and settle the matter, or I will file a complaint. So unless you talk to me, I will do this. Unless X, then Y. The subject line, desire not to have to file a formal complaint with the NCJD. I mean, in exchange for what? So Mr. Blandino, putting himself out there as an investigator for the NCJD, tells Mr. Federico that he came to your office to see if I can meet you man to man and see if he could resolve my complaint with you without having to use scarce judicial resources and NCJD resources, as I have attempted to do with other misbehaving judges. Now, we're going to talk about the impersonation charge in a minute, but let's just go to that. I am an investigator with the Nevada Commission for Judicial Discipline. Mr. Blandino is not an investigator for the Nevada Commission for Judicial Discipline, never has been. But by announcing himself as such, he holds himself in that authority. When he's writing this letter, he is putting on the cloak of authority that the NCJD has over judges, including municipal court judges who are public officers and who are subject to judicial discipline. And Mr. Blandino puts that at the very top of that letter, and then goes on to say, I need you to start talking to me, or I'm going to file a complaint with the Nevada Commission for Judicial Discipline. To avoid having the NCJD subject this complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney and I, if you wish to have an intermediary. I will do X unless you do Y. May 3rd, 2019, I mean, this settlement demand is essentially a quid pro quo, which is this for that, in consideration, meaning in exchange for. So in exchange for Judge Pro Tempore Federico paying $25 on to defendant for that jobs, in exchange for Judge Pro Tempore Federico writing a written apology to Mr. Blandino, in exchange for Mr. Federico acknowledging that the defendant can insert court whenever he wishes, and in exchange for Mr. Federico completing that ethics course or paying that $500 to the Clark County Law Library. In exchange for that, the defendant agrees that he will not file a complaint with the NCJD, and he will withdraw and dismiss the municipal court complaint form that he had previously filed with the municipal court. If not X, then I will do Y. So this is, on one hand, Mr. Federico has to do the things that Mr. Blandino is demanding in the settlement agreement, and on the other hand, Mr. Blandino agrees that he will not be filing that complaint. He will not be imputing disrepute upon Mr. Federico. He would not be filing any complaint that could bring that disrepute upon an individual who acts as a judge. Mr. Blandino goes on in this agreement to state essentially that, this agreement bars Mr. Blandino from filing that complaint with the NCJD and the court or agency or any reviewing entity whatsoever with respect to the April 25th issues. Words matter to Mr. Blandino. I'm sure you guys noticed that when Mr. Blandino was on the stand, he was very particular about the words that were used, about the questions that were asked. Mr. Blandino had a hard time answering questions with a yes or no when that was what was requested. Mr. Blandino is peculiar with his words and particular with his words. And I would note that on the stand, Mr. Blandino said, oh, but I should have put in there that I would have sent that settlement agreement to the NCJD anyway. Because, hey, if Mr. Blandino is that particular with his words, that would have been in that settlement agreement. May 8th, 2019, again, Mr. Blandino at this point is extremely frustrated. There has been that call between Mr. Federico and Mr. Blandino. And Mr. Blandino wants a response to that settlement demand. He wants a response because he spent a lot of time working on the settlement demand, a lot of time working on his letters, and he wants to make sure that that little bit of power that he had over Mr. Federico keeps going. So I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23rd, 2019. I sincerely hope we can settle things. And when we talk about the settling things, again, I would note that this refers back to that settlement demand, the settlement agreement that Mr. Blandino drafted. In this case, and this is the letter in which Mr. Blandino threatens to accuse Mr. Federico of federal complaint, and the letter in which Mr. Blandino threatens to go to Mr. Federico's bosses and accuse Mr. Federico of judicial misconduct. So if we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you. Again, if you do not do X, then I will do Y. Textbook extortion, ladies and gentlemen. Again, the threat of reporting this to Mr. Federico's bosses, I will do this if you not do Y. Textbook extortion again. So again, it doesn't matter that whether or not Mr. Federico pays that money, doesn't matter whether Mr. Federico ever actually sat down with Mr. Blandino, doesn't matter if there was an apology, the $500 to the Clark County Library. This is extortion. So there is a threat that was made to accuse Mr. Federico of a crime under 18 USC 242, and there was a threat to impute on Federico disgrace, which I'm going to go to your bosses and tell them that you're a bad judge. So we have Mr. Blandino threatening to accuse Mr. Federico of a crime and threatening to impute on Federico any disgrace. So that threat element for the extortion charge is met, ladies and gentlemen. Now, the intent. Extort or gain property or money. Mr. Blandino asked for that $25, asked for that $500 to the Clark County Library. That is trying to gain money or property from Mr. Federico. And again, I would tell you, this is an either or. Not all of you have to agree on what Mr. Blandino's intent was according to this element. Some of you may believe that his intent was to extort or gain property or money. Others may agree that Mr. Blandino's intent here was to influence the action of a public officer, because you have that instruction. Mr. Federico, when he is sitting as a judge pro tempore in municipal court or as an alternate judge in municipal court, is a public officer. So what type of influence is Mr. Blandino trying to get? He is trying to get a either public or written apology from Mr. Federico in exchange for not accusing him of a crime, in exchange for not filing a judicial complaint, in exchange for not reporting Mr. Federico to his bosses. He is attempting to get an apology, and he is attempting to have Mr. Federico agree that Mr. Blandino has free reign over the courtroom. There's your intent. And again, whether or not the purpose that is intended is accomplished doesn't matter. The intent was there when the threat was made. Mr. Blandino is guilty of extortion. Count 2, impersonation of a public officer. Every person who shall falsely personate a public officer, civil or military, or a police officer, or a private individual having special authority by law to perform an act affecting the rights or interests of another, and in such assumed character shall do any act purporting to be official, whereby another is injured or defrauded, shall be guilty of impersonation of an officer. So, a few elements here. We have falsely personating. So basically, Mr. Blandino needs to pretend to be a public officer. The public officer we have here is an investigator with the Nevada Commission for Judicial Discipline. In such assumed character shall do any act purporting to be official, here communicating with a judge pro tempore, talking about negotiating with a judge pro tempore while claiming to be an investigator, and whereby another is injured. Mr. Federico told you that he was injured. He suffered mental anguish, and he was stressed, and he thought he was going to lose his job. He was scared for his children. He testified that he began carrying a firearm because he was so frightened for his wife and 6 children. Mr. Federico sat up there and teared up. Mr. Federico was extremely scared of Mr. Blandino at the time. So, here are your elements. Someone needs to pretend to be a public officer, do an action purported to be official that causes injury to another. Okay, defendant does not work for the Nevada Commission for Judicial Discipline. He's never worked for the Nevada Commission for Judicial Discipline. However, Mr. Blandino is incapable of admitting that he does not work for the Nevada Commission for Judicial Discipline. Paul Diley sat up there and told you it doesn't matter whether you tout yourself as a volunteer or official or unofficial. Mr. Blandino is not an investigator, nor has he ever been. So the Nevada Commission for Judicial Discipline will have an instruction detailing what that is. It's established by law, by the Nevada revised statutes, by the Nevada Constitution. The procedure is essentially, there's a complaint that's confidential. The commission staff, including Paul Daly, review that complaint, that initial complaint that can be made by absolutely anyone, including Mr. Blandino, and determine whether it meets a certain threshold of proof. If they find that it does meet that threshold of proof, the next step is they authorize an investigation. Mr. Daly told you that when it comes to their investigators, there is a very set category of people who meet that standard. Mr. Daly told you that they use the same firm, and when they engage these investigators to work for the commission, those investigators become public officers. Once the investigation is done, and at this point it is still confidential, once the investigation is done, the investigators submit reports to the commission reviews the evidence and determines whether or not they need to get a response from the judge. The judge response is reviewed by the Nevada Commission for Judicial Discipline, who again at that point determine whether or not charges need to be brought against the judge. Investigators have special authority under Nevada law. Specifically, they can compel judges, lawyers, and full court staff. They can compel the production of court documents. They can compel cooperation by judges, officers of the court, who have to comply and provide documents. Those investigators that Paul Daly mentioned are separately licensed under Nevada law, and they become public officials when the NCJD brings them into an investigation. Mr. Blandino's only role when it has come to any type of investigation by the NCJD has been to file that initial complaint. Mr. Blandino does not investigate for the Nevada Commission for Judicial Discipline. Mr. Blandino investigates for himself. Let's be clear. He investigates for himself because he wants to get that power and control over the judiciary. Mr. Daly, Kim Blandino is not or ever has been an investigator for the NCJD. He's not an investigator for his commission. This is everything Mr. Daly testified to. It causes me concern when someone who is not authorized by the commission is holding himself out as an investigator. Mr. Daly testified that no charges were brought against Mr. Federico, nor was any discipline ordered. And there was this interesting exchange because Mr. Blandino's new tactic, at least on the stand, was to claim that he actually says that he's an unofficial investigator. Therefore, that means that he can do it. But Mr. Daly disagreed. Defense counsel, Mr. Blandino indicated that he was an unpaid volunteer investigator for the commission. Wouldn't you agree?
I mean, she's
Wouldn't
still
you infer
going
that
on with
unpaid
this?
Volunteer isn't anything official. Paul Daly.
Oh,
testified
Jesus
that I would
Christ,
not agree
lady.
with that.
This is not OJ. This
So,
should be like a
it
20-minute
doesn't matter whether or
presentation.
not Mr. Blandino is paid or unpaid. It doesn't matter whether or not Mr. Blandino is a volunteer or employed officially by
Oh,
the
who's
Nevada
typing?
Commission
I
for
hate
Judicial
that.
Discipline. Mr. Blandino cannot say that he is an
Hold on.
investigator
I'll do it too.
under with any act.
Uh-oh. Oh, I killed something. Sorry. That keyboard clicking is just drives me up the wall.
The Commission for Judicial Discipline. I'm an unofficial investigator.
This is an unnecessary
So-
closing.
Again, the defendant has claimed
Hey,
to be an
Gixer, how you
investigator
doing?
for the Nevada Commission for Judicial Discipline over and over again. In all these letters.
Yes, over
to
and over again. Your
Mr.
fucking
Federico,
closings over and over again.
starting
Sugar
on April
britches, come
25th,
on.
2019, I am an investigative reporter and an unpaid volunteer investigator for the Nevada Commission
I'll
for
fucking
Judicial
run out of
Discipline
these
to
before it's over.
investigate judicial misconduct and corruption. I was there today
That
in
gum
these
thing.
joint capacities. So not only is
I'd
Mr.
rather see
Blandino
it's in that
telling
gut.
Mr. Federico in this April 25th letter that he is an investigator with the Nevada Commission for Judicial Discipline, but he is saying that he showed up in court that morning under that cloak of authority.
She's
He
an unofficial
showed up
closing
in
attorney.
court as an investigator for the Nevada Commission for Judicial Discipline. That is what that statement means.
Oh my gosh. I should have gone
Again,
back to playing
May 2nd,
squad.
2019 settlement demand.
Could have played a whole game in this time
Complainant
she's
Kim
done this.
Blandino, pro se litigant, and investigative journalist and volunteer
Talk over my glasses
unpaid
like she does, like-
investigator for the Commission on Judicial Discipline. Mr. Blandino is putting himself out there as
There, I covered up her
a
mug
public
for you,
official
Stacy.
for the Nevada Commission for Judicial Discipline. There are no investigators pre-complaint to the Nevada Commission for Judicial Discipline. That does not exist under the NCJD rules. May 8th, you can
This
ask,
keyboard
you can
clicking
ask
is-
just about anyone in the
this
RJC,
typing
and
is
they will
killing
tell
my
you that Kim Blandino is investigating
ADD.
judicial
It's really
misconduct and
making me
corruption and
scream.
has done so for many years.
It's like sitting through the bar exam all over again. I almost had a panic attack listening to everybody type.
Again, Mr. Blandino goes on and tells any threat to tell Mr. Federico's bosses that
Oh,
Mr.
Jesus
Federico
Christ.
was mean to him that morning and
Christ on a
was a bad
cracker.
judge to that morning. Mr. Blandino says,
But
I
many
would not want
cases
anyone
for you.
associated with a firm that had my good name on it, associated with a member of the bar that excluded a member of the public from an open courtroom, let
Yes, Matthew.
alone an investigator and journalist from a public courtroom.
You're gonna have to
Now,
go investigate why
again,
she made me blow
Mr.
my head
Blandino
off.
is threatening Mr. Federico here.
We get it. He
with
threatened the
disgrace from his
judge.
bosses,
You've
but
established
also
that.
saying that
Tie the
it's
story
even more
together.
egregious that you would do it when I was an investigator for the Nevada Commission for Judicial.
That's generally something done in federal court, but he probably is a vexatious litigant.
Defendant again, this was the exchange I mentioned where Mr. Blandino is incapable of admitting that he does not work
Wars.
for the Nevada Commission for Judicial Discipline. So Mr. Blandino, you're not an investigator for the Nevada Commission for Judicial Discipline. Well, I'm an unofficial investigator. Mr. Dickerson, so are you telling the jury that you are an investigator for the Nevada Commission for Judicial Discipline? Mr. Blandino, unofficially, yes. Mr. Dickerson, no, you're not, sir. And Mr. Blandino, well, that's not true.
If I take my headphones off though and listen to
When
the sound through my
confronted
monitor,
by
I think you
Dickerson,
guys can hear
You
it.
heard the testimony of Paul Daly, same as I did, right? That you are not and never have been an investigator for the Nevada Commission for Judicial Discipline.
Oh my God.
And Mr. Blandino sat right here
Yes, you do.
and told you,
Everything
disagree.
Mrs. Martin
I'm an
going boy
unofficial
needs.
one. So, ladies and gentlemen, Mr. Blandino is still putting himself out there as an investigator for the Nevada Commission for Judicial Discipline. He's met the elements in terms of putting himself out there as a public official, pretending to be a public official, doing an action purporting to be official, that being to investigate judicial misconduct for the Nevada Commission for Judicial Discipline, which he was not authorized to do by the Nevada Commission for Judicial Discipline. And then you have the injury to Mr. Federico, which I mentioned. The worry about losing his job, the worry about getting in trouble with the farmers,
I will
the
row
worry
across
about
the Atlantic in a boat and
losing
kill
his
you if you do
additional
that to
employment
me.
as a judge pro tempore should the complaint be filed with the commission, as well as his physical fear of Mr. Blandino. So impersonation. Those are the elements,
And
and
I'll use a
ladies and gentlemen,
spoon
they
to
are
do
all
it.
met. Mr. Blandino pretends to be an investigator for the Commission for Judicial
To quote the
Discipline. He's a
great Alan
public officer.
Rickman.
He does actions purported to be official, so he tells judges that he is investigating misconduct and they need to sit down with him, basically, or else
Yeah, she
And
probably burns out her
it
projector
caused an
bulb at some
injury to
point.
another, in this case to Mr. Federico. So let's talk a little bit about the potential defenses we have here.
Oh,
Mr.
fuck's
Blandino,
sake.
may
Your
allege
clicker's gonna run out of
defense against
batteries,
the law.
lady.
You might say, look, I didn't know that what I was doing was wrong.
I have a defense. You're taking too
He
fucking
might-
long.
And Mr. Blandino has said that his religious beliefs require the actions he took. Mr. Blandino has said over and over again, his religious beliefs require that he settle matters. His religious beliefs.
His religious beliefs
speak in a manner that
involve him
he does.
harassing government officials.
Finally.
I actually
the
might want to
defense
join
of
this
entrapment.
religion.
Now,
It sounds
let's go
fun.
through those one by one. Mistake of law. You have an instruction on that because you have an instruction on everything. So ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus,
Unless you're a
when
police
the evidence
officer and you're
shows
claiming
the
qualified
person
immunity.
voluntarily did that which the law declares to be a crime, it is no defense that he did not know that his act was unlawful or that he believed it to be lawful. So, Mr. Blandino testified on direct If there was any extortion, that was a mistake on my part. Ladies and gentlemen, that's not a defense. The question you need to go back and deliberate on is, have the elements of the crimes been met? And I would submit to you that they have. So mistake of law is out. Ignorance of the law is no excuse. Next potential defense, religious beliefs. Defendant again stating that his religious beliefs required everything that was done. A defendant's religious beliefs are neither a defense nor an excuse to the crimes of extortion or impersonation of a public officer. The right to engage in actions or conduct prompted by religious beliefs or principles remains subject to criminal laws enacted by the state of Nevada. And if you think about it, that makes sense because we're a government of laws. We're not a government of individuals. The laws dictate what everyone must do. The laws need to be generally applicable. If a person's personal religious beliefs could exempt them from certain laws, what use is the rule of law? What use is having a generally applicable law? You got your typical example of taxes. Some people think they don't need to pay taxes for religious reasons. Some people believe that, they can have 5 husbands or wives for religious reasons. Age of consent. So there are so many examples of laws that the state has that apply to everyone that individuals may believe their religious beliefs exempt them from. There is a reason the religious beliefs do not excuse or defend against criminal action. So Mr. Blandino's religious beliefs, while they are sincere, are not an excuse to the crimes of extortion and impersonation of a public officer. The question you must ask yourself is not, did
This
Mr.
is
Blandino
what's called death
believe
by
that
PowerPoint.
God
You
was
start
telling
making a
him to do this,
PowerPoint, you
but
don't
rather,
stop yourself.
did Mr. Blandino commit the elements of each of these crimes? And the answer to that is yes. He committed those crimes. So religious beliefs,
He committed those crimes.
not an applicable defense.
Yay! Ta-da! Done.
Finally, the defense of entrapment. So the defense of entrapment is an affirmative defense the defense must raise, and they have. That being that they need to argue that there was some instigation by law enforcement. So that phone call of April 29th is what we're really talking about here. That is the law enforcement action that defense claims constituted entrapment. But once that defense is raised, the state must prove that the defendant was predisposed to commit the crime. Ladies and gentlemen, Mr. Blandino was predisposed to commit this crime. Mr. Blandino testified that he had sent letters such as the ones he sent Mr. Federico to dozens of judges. He testified that this was just the first time someone had ever responded, but he had done it a lot. So predisposition, again, an instruction of things you may consider to determine whether or not Mr. Blandino is predisposed to committing extortion and impersonation of a public officer. So you may consider his character, you may consider where that first suggestion of criminal activity comes from, whether Mr. Blandino was engaged in criminal activity whether he was engaged in activity for profit, whether he was reluctant to take advantage of the opportunity presented by law enforcement, and the nature of the inducement. So going through those very quickly, the defendant's character, again, you saw Mr. Blandino's demeanor throughout these proceedings. You saw his demeanor while Mr. Federico was testifying. You saw his demeanor on the stand. You saw Mr. Blandino's inability to answer questions directly. And you saw Mr. Blandino's desire to control the testimony. Furthermore, I would submit that first suggestion of criminal activity, that first suggestion of extortion, came from Mr. Blandino in that very first letter on April 8th, 2019, wherein Mr. Blandino stated, "I am ready to begin filing my complaint against you. I need you to meet with me to negotiate a settlement." Ladies and gentlemen, that letter on April 25th, 2019, where Mr. Blandino followed through saying, "I want to meet man to man. I want us to settle matters. I need us to negotiate." Those are the first suggestions of criminal activity. Those are the first suggestions of extortion that came from Mr. Blandino. Engaged in activity for profit. We're not alleging that Mr. Blandino is in this to get rich. We're not. Mr. Blandino wants power. Mr. Blandino wants control. Mr. Blandino wants $25 for the repayment of the jobs. So specifically though, I would note that there was no reluctance whatsoever on Mr. Blandino's part when it came to whether or not to take advantage of that phone call and Mr. Federico's willingness to talk to Mr. Blandino. Mr. Blandino was giddy. Mr. Blandino was happy. He was excited. Mr. Blandino went on and on for approximately 18 minutes where he controlled that conversation. And Mr. Blandino demanded a public apology during that phone call. When that conversation ended, within 3 days, Mr. Blandino had drafted a multiple-page settlement demand. So, ladies and gentlemen, I would submit to you that entrapment in this case is not a defense. Mr. Blandino has sent letters to judges before, has filed complaints against judges before, has sent similar letters as he did to Mr. Federico to other judges before. And Mr. Blandino took advantage of the opportunity that was provided to him when, for the first time, someone actually decided to give him a little bit of power. There's your testimony that I was speaking of. Truthfully, he, meaning Mr. Federico, is the only one who ever came back. And everyone else, they just pretty much ignore me, and I just filed my complaint, and in a few cases, they issue a few letters of caution to the judges. Mr. Blandino admits to sending similar letters. This is not entrapment. The defendant here was predisposed to committing extortion. How else do you know that? Look at the photographs from that search warrant. There's Mr. Blandino's room, his mission control center, with all those computers. And then there's his filing system. There's all that paperwork that Mr. Blandino has in his bedroom. There's a file entitled Screw Ups. And there's a file entitled Federico Case. Ladies and gentlemen, Judge Screw Ups, all those documents in that filing cabinet, I would submit to you that the defendant has done this before. He admitted he's done this before. That is predisposition. That is predisposition to commit extortion. So entrapment is out. Now, let's talk a little bit about Don Quixote. In opening, Mr. Bateman told you that Mr. Blandino was like Don Quixote, right? He wants nothing for himself. However, what he does want is, $25, an apology, free access to a courtroom, and for a public officer to do an ethics course or pay an additional fine. Mr. Blandino wants nothing for himself except for Judge Federico to settle matters expeditiously. Or else, Mr. Blandino is going to file a complaint with the FBI for a federal crime. Or else, Mr. Blandino is going to complain to Mr. Federico's bosses about Mr. Federico's alleged misconduct. So, Mr. Blandino wants nothing for himself except the ability to exercise some control over one judge who got back to him and gave him the feeling that he could get that control. Mr. Bateman told you, defendant was within his rights to observe court and submit complaints to the Nevada Commission for Judicial Discipline. And absolutely, Mr. Blandino can file as many complaints to the Nevada Commission for Judicial Discipline as he wants. What he is, however, not entitled to do is decide to settle matters for himself. Mr. Blandino cannot play the investigator. Mr. Blandino can file a complaint. If I'm driving down the freeway and I see one car ram another, I can call 911. I can't track one of the cars back to the house and then start trying to talk to the to the perpetrator, cloaking myself in this cloak of authority, like, hey, I'm a volunteer police officer here, so tell me what happened. I can't do that. Ladies and gentlemen, he can enter court, he can file complaints, he cannot investigate, and he certainly cannot investigate when he's saying he's investigating for the Commission for Judicial Discipline. Mr. Blandino also told you, I got a deliberate plan to help the NCJD with their plan. Mr. Blandino wants to help the Nevada Commission for Judicial Discipline. That's great. However, Mr. Blandino says he's doing all this for other people. In his letters, the defendant is saying, I am doing this for everyone else who may appear in front of you because I don't think you have the temperament for a judge, essentially. If that were the case, ask yourself this. What was that gap in that timeline? Why not file that complaint to the Nevada Commission for Judicial Discipline as soon as that August 28th, 2018 trial resulted in Mr. Blandino's conviction? Why wait 8 months? Mr. Blandino, I will submit to you, waited 8 months because he wanted to try to win on appeal, but he lost on appeal. Mr. Blandino lost a trial, he lost an appeal, and then he decided that he was going to take matters into his own hands. If at that point he decided to just file that complaint, fair enough, but that's not what he did. He decided to try to settle matters, he decided to threaten the judge, he decided to keep impersonating a public officer. Mr. Blandino, again, tells you that if at any point Mr. Federico said, stop, I didn't stop. He did. Mr. Federico told him to get out of the courtroom. Any reasonable person would infer from that that means stop. That means leave me alone. But no, Mr. Blandino keeps showing up. Keeps showing up where he knows that he can get some power over Mr. Federico. And Don Quixote wasn't tilting at windmills for fun. Don Quixote thought he was a knight. Don Quixote wasn't actually doing anything for himself. Mr. Blandino was. Mr. Blandino was doing things for himself, and he was doing this. What's his motive behind all this? He's doing this for fun. If you're not having fun, you're not doing it right. That's what Mr. Blandino told you a couple hours ago. Ladies and gentlemen, Mr. Blandino is not Don Quixote. Mr. Blandino's intent and motive during this entire case was to gain power, was to gain control, was to cloak himself in the authority and power of a statutory and constitutional commission in order to try to get that modicum of power over a judge who had already found him guilty. You have an instruction on credibility, and it basically says, consider everything, consider the testimony, consider the demeanor on the stand. That's also applicable for Mr. Blandino. You've seen him throughout this entire trial. You've seen him at defense table. You've seen him on the stand. You've seen his attitude. You've seen his response to questions. So you've also seen Mr. Federico. You've seen Mr. Federico, who admits he got upset, he got annoyed during proceedings. However, Mr. Blandino himself said, there is a right to maintain control over a courtroom, and that's what Mr. Federico was doing in August 28, 2018. You sat through that trial twice, so you saw exactly what type of control needed to be exercised over Mr. Blandino in order to maintain the proceedings and the rule of law on August 28, 2018. You saw Mr. Federico tear up. You saw how choked up he was when he thought back on how scared he was for his family. And you saw Mr. Blandino laugh. You heard Mr. Blandino a couple hours ago tell you, well, that was pathetic. Those were crocodile tears. I was laughing because those were actor's tears. Ladies and gentlemen, I would submit to you that you should consider Mr. Blandino's statements as to that. I would submit to you that you should consider Mr. Blandino's behavior throughout Mr. Federico's testimony and throughout his own testimony. And I would submit to you that Mr. Federico was in fear. Mr. Federico suffered injury from Mr. Blandino's actions. Now, again, this is about the rule of law versus the rule of Blandino. The rule of law being that all persons, institutions, and entities are accountable to laws that are publicly enacted, equally enforced, and independently adjudicated. This is about the independence of the judiciary. That is the bedrock of the rule of law. And this is a trial about, the rule of Blandino, which is basically whatever rules you say they are. When the rule of law disappears, we are ruled by the
Oh
rules of
my
man.
God,
Ladies
stop.
and gentlemen,
Honey, you're done.
when you go back to your deliberation room,
I mean, I don't like
You're gonna
using
have
honey,
this
but
verdict
God,
form.
you got to. Lucas, have a good one.
Mr. Dickerson on rebuttal will come up here and ask you to find Mr. Blandino guilty of extortion and guilty of
Do
impersonation.
you not
of
like
an
her vocal
officer.
fry?
Show Mr. Blandino that it is not the whims of men that control, that it is the rule of
Vocal
law.
fry.
Okay, at this time, we're gonna take a recess. During this recess.
Oh, thank you, Jesus.
With anyone, including your fellow jurors, may waive regarding the case or its minutes either by voice, phone, email, text, internet, or other means of communication, or social media, or read, watch, or listen to any news or media accounts or commentary about the case, or do any research, such as consulting dictionaries,
I was about
using the internet,
I was
using
about to
reference
experiment how
materials,
hard I could shove
in
this through
any
the palm of my
investigation,
hand.
tested through the case, recreating aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case, till it's finally
I mean, this wasn't
submitted
even a
to you,
murder.
or be
I've been in
tested
front of
10
judges with it have been
Thank
like,
you, all right, correction, jury, please, third.
I would have been in front of judges and said, sorry, wrap this shit up, man. What time is it there? Oh, they're like 3 hours behind or 2 hours behind. You guys are worried about her being hot. She's hot enough. She's an educated woman in 2022 who does not look to appear to be married. That should be enough for you guys, you young bucks out there. Is this the music from their feed? This like intense like boss fight music I'm hearing? Or am I having a stroke? Yeah, you don't get water. Water's for people who get their shit done on time. You don't get to drink water now. Jeez, you guys are rough. Shit took so long. Matthew's probably already at work for his next day already. She talked so long, no man can get a word in. Ooh. God damn. Man, I see the smoke all the way from Canada now. That was unnecessary. That was unnecessary. That was 100% ridiculous. That was not needed at all. No, I'm not saying you guys. I'm saying her closing. Holy shit. Her closing was longer than the case. Really, am I hearing like intense video game music right now, or is that just me? Really, am I the only one who hears that noise, that music? Oh, it is from the stream. It's like I'm getting ready. Yeah, I can hear it. I can hear it through my headphones. It's coming from them. It's like riding up the elevator to get ready to fight the boss in a video game. You come out the elevator with your sword, and the monster's like, whoa! It's like some Elder Ring shit right there. Streamer's a gamer. Ah. But this is the being on hold. This is very intense being on hold music. If I started hearing this, I'd be like, okay, who's attacking me? What? Hold on. Roxy, I don't know if I've seen you before, but if it's been a while, welcome back. If I haven't seen you before, welcome. Like and subscribe if you want to see more. Oh my god. So do we think Blandino's going to do it? Or does his defense attorney have to do the closing? Oh, it looks like he's going to do it. He's got a legal pad. They're going to make him do it. She's on trial. Do you know this lady's name, Bob? I'd be curious to look at it. And we might talk about it coming up. Oh, his attorney did the opening? Oh. Fuck, I wanted to hear Kim do his thing. Oh my god. Kim, don't talk to the prosecutor. He does not want to talk to you. He is not your friend. He wants you to get the fuck away from him. Quit talking with cringe, bro. One thing about sovereign citizens, they're lunatics. And in fact, they can be very dangerous at times. One of the few times in my life I thought I would actually have to kill someone involved a sovereign citizen. Like things got that intense at one point. But other than that, I mean, they're a nuisance. They're mainly harmless and stupid, but you know, the only thing I will give them credit for pointing out is the whole argument of the freedom of travel. You know, and people, you know, the police will respond, well, you don't have the right to drive a car. It's like, you don't apply that to any other right. It's imputed you can use modern means. But, you know, I think that's the one place where they do have a valid argument. The rest of it's all nonsense using the UCC, which we may talk about that. Uh-oh, what did I say, Critter, that makes y'all wowzers? Critter, I don't know if you heard me, but what was the wow comment about that? I agree with their argument on the right to travel, or... Oh, yeah, well, things got a little intense, and I was accosted in a parking lot. Yeah, I thought I was going to have to do it, but he backed down. But, oh well. He thought better of it. But Lori had the freedom to travel. Deronda Vaught. I'll Google this one right now. Yeah, Roxy, we're going to do the Daniels trial next week. I am not. Husel, unless there's some massive, it explodes, I'm not going to get involved in that. Okay. What the heck kind of say my name is Deronda. I mean, it's a name, but. Okay, we're going to switch over for a minute. Okay, Sue, you didn't like him? Okay. Oh, Critter, it was okay. It was fine in the end. And even if I had to kill that guy, God, that makes your street cred go up with criminal defendants. So we're going to take a real quick break, and we're going to check out this case that Bob sent us. I think it's interesting. Okay, so Deronda Vaught, looks like she is being charged with homicide. And this is Deronda Vaught, it looks like. Whoa. What are we doing here? Okay. So it looks like she faces potential jail time. She worked at the hospital. She was indicted on abuse and reckless homicide charges after she gave the patient the wrong medication. But it looks like there's a lot more to it. So here's some stuff we can look at. She got hired in 2015. Charlene Murphy was bleeding on her brain. Okay. She's almost ready to leave. She was supposed to be given Versed so she could get a scan done. But she was accidentally given a dose of vercuronium and she was paralyzed and that left her brain dead. Huh. She admits the error. Okay. Well, that's not okay. So apparently, it wasn't reported exactly what happened to the medical examiner. So it wasn't independently investigated, huh? Oh, we're back. We're back. All right, we'll catch up on that in a second. We'll check that out after this is over. Well, actually, you know what? We're gonna go back to it while we're still waiting. Yeah, this is weird. This one starts reading very weird, and I don't. Hopefully, the story susses it out because I'm really confused. Okay, so there was, it sounds like the doctors above her covering it up, but how's it her fault? Vanderbilt officials take several actions that obscure fatal medication errors. Oh, wow. Okay. We're kind of getting like a Dr. Husel vibe from it. They negotiate an out-of-court settlement with the family. Okay, that makes sense. That's normal. So somebody reported she died. The death. So they determined she didn't break any rules. It was just a violation of, her doing her job right. They don't discipline her, but sounds like they fire her. I guess we're back. Oh, great. I come back and it black screens us.
No,
Lights on.
the red light comes on.
Okay, we're like what, waiting again?
Gotham
Oh,
City.
damn it.
Thank you, everyone. Please be seated.
Does the state stipulate to the defense of the jury panel
We do, Your Honor.
and the defense?
Yes.
Mr. Bacon, may I address the jury? Closing argument.
What a week.
What a
Quixotic. Remember that word? Remember what it means? Foolishly impractical in the pursuit of ideals. Okay? Does that sound like anyone you know? Okay, again, going back to Don Quixote, statement, people thought he was eccentric, they thought he was odd, not only for trying to bring back chivalry and honor to Spain, but probably more so for the way he went about it. Jousting at windmills, doing all the sort of things that just didn't seem to make sense to anybody. But I told you my opening statement, despite all of Don Quixote's shortcomings, he never lacked sincerity in his quest, ever. Okay, and similarly, Mr. Blandino's actions might make you think he's eccentric and odd or just plain foolish, whatever. And that's fine. You are entitled to have your own personal opinion about it. And maybe now, hopefully, makes a little more sense if you remember last week during jury selection, right? I asked you, are you able to separate your personal feelings for Kim Blandino and only look at the facts? I asked you on a what do you call it, on a sliding scale, right? From 0 to 10, right? 10 being, yes, absolutely, I can totally do that, right? I can totally separate any personal negative feelings that I might have for Kim Blandino and only look at the facts. Well, now is the time to prove that you can separate any negative feelings that you might have for Mr. Blandino and only look at the facts here, right? What did Kim Blandino really want? You'll see that through all his correspondence, all his letters, everything, all he wanted was just to sit down and talk things over to see if there's common ground. You remember Detective Meade said that's not illegal to ask to meet with someone, right? They called him, right, on April 29th. They called him and asked him if he wanted the judge to reverse a ruling, right, or take away contempt time. He said, no way, that's illegal. If you'll recall, when he was testifying, he said, and he suggested that, and I said, you might want to talk to an attorney, that's illegal. And there's almost a childlike innocence in that, okay? He didn't know that the cops were listening in, that they were trying to set him up. He wanted to meet. They didn't want to meet him, but they couldn't be honest about it. They led him to believe that they would talk with him, deal fairly with him. Remember, this is the guy who takes everything literally. And you saw him sprint to the water fountain because he thought he had 10 seconds. I personally chuckled the first time I saw it because I didn't really think he meant 10 seconds literally. Okay? But you can tell Mr. Blandino is very literal. And the sort of consistency in his literalness is no act. You heard it on, they kind of said, well, he can't really answer a straight question. But for example, like, well, you went to his private office. Well, no. His private office is like where his desk and computer is. I went to the reception area of the main office, right? Or the docket or the register of actions. It's untitled register of action. That's what Mr. Dickerson referred to the document. Or the letter when you said, no, I wrote. He's very literal. We saw many examples of that, him being very literal. So that's the guy that they're leading to believe that they'll talk to him. That they'll
So we're
deal with
using
him,
he's
right?
a big idiot defense.
It's sort of kind of the ticket in, right, is to send me something specific, right? He had no idea really what he wanted, okay? And you can tell, really, he didn't want anything for himself, like nothing, absolutely nothing for his own benefit, right? Take a class, Mr. Federico, that's for your benefit, it's not for Kim. Donate $500 to the Clark County Law Library, it doesn't benefit Mr. Blandino, okay? Now they're trying to hang their hat here, on the $25 he asked for, but it's very clear in the documents that money is to reimburse the person who loaned Kim Blandino the $25. And, an apology in writing, what's that word? Right, remember, he still thinks this is some kind of legitimate kind of discussion or negotiation or whatever you want to call it with Mr. Federico. And he alluded, and Mr. Federico, so he thinks this is like, I'm sure he thinks he's out of his league. He's dealing with, with attorney. Mr. Federico alluded to the fact, negotiation tactic, you ask for more than what you want to really get what you want. And so we're supposed to believe that the guy who had to borrow $25 to get the court video isn't asking the big shot lawyer who works at the big prestigious big shot law firm for any money for himself, right? Do you see the sincerity of purpose in that? He's Don Quixote. He's bringing chivalry back to Spain. He's trying to make sure that things are better in the future with his requests. That's all. He testified to that. Now, in their opening, their closing, the government said that this was about the rule of law, right? And that Kim is a dangerous threat to that very rule of law. And I don't really see it that way. Okay, what I see is about kind of the powerful and the powerless. Yeah, he wanted to affect change, right? And really, the only threat to the rule of law is about the abuse of power. I mean, anyone can file a complaint with the Nevada Commission on Judicial Discipline. And because Mr. Blandino can do that,
The keyboard
he's
clicking
certainly within his
again.
right. We've established that. And he's within his right to go and ask to see if Mr. Federico would meet with him. But his efforts are met with disdain and contempt, right? He's really asking for an opportunity to be heard, but it's just like, what does he get? He gets that, it's like, who's this guy? Who are you to come here and want to talk to me? And it's not in any way improper for him to talk to or want to sit down and talk to him. Do you recall about the phone call on April 29th, over and over repeatedly, he said he just wanted to meet. He wanted to meet Mr. Federico. So, yeah, he kept saying he wanted to meet me. He wanted to just to talk, right? You recall, he went in there April 8th because he said the Holy Spirit directed him to. He went there with no agenda, no list of demands, nothing. The guy you see here bringing 5 bankers boxes full of stuff and looking at, and I had to borrow a piece of paper to write a note. He had no agenda, no intention to extort anything. Okay? And you have your jury instructions, and you have instruction on reasonable doubt and the burden of proof, right? The burden of proof is here on the government's shoulders. That's proof every element of every crime charged beyond reasonable doubt. Okay, they can't prove most of the elements beyond a reasonable doubt, and it's like, okay, that's close enough. No, it has to be every single element. And the failure to prove any one of these elements beyond a reasonable doubt, has to result in a verdict of not guilty for that crime. And that's our system here. This is the way our rule of law and our judicial system is set up. Okay? It never imposes on Mr. Blandino or any defendant, okay, the burden of proving anything. And that is our system. So by law, our defendant starts out to say this is innocent here, right? Guilty here. He doesn't start out anywhere in the middle. He starts out with the presumption of innocence, and it's a hefty burden to get him all the way to a guilty verdict. And anything short of that has to result in a not guilty verdict, even if you don't like him. You don't have to like him. Not that you need my permission, but you have my permission to not like Mr. Blandino. Okay, and there's one of those in the jury instructions that states that every crime there has to be a union of act and intention. Okay, and one of the essential ingredients, of the crime of extortion, okay, is the intent to extort money, gain property, or accomplish any of the other things listed in the law. Okay, by any of those other means listed. So you got to try to accomplish something by the means listed in the statute there. And the intent to do that is really what's at issue here. You see, extortion is a type of theft, really. Okay, it's a theft crime. You can be a thief by robbing someone at gunpoint, shoplifting, pickpocketing. Those are all thefts, but by different means here. We used to call this crime blackmail. Okay, it's the means by which the theft, whatever, is committed. And so this case really hinges on Mr. Blandino's intent. Okay, did he really mean to extort anything of value? Okay, no. Okay, he didn't seek any money or any gain for himself. $25 is going to someone else. $500 is going to the public law library just down the street here. Okay, the class is to help Mr. Federico. This is all to make the world a better place in the future. An apology? What's that work? Try depositing that in the bank. Or next month, April 15th, they said talking about paying your taxes. I believe they did on closing. Try paying your taxes with apologies you've received in taxable year 2021. Okay? The other portion, influencing the actions of a public officer. No, he didn't do that. They tried on that phone call. They said, hey, do you want me to take away the contempt time? Do you want me to vacate your fines? Right? It was something to that effect. Everyone that testified, 4 people testified as to that phone call. All of them consistently said, we asked him, do you want me to do basically something illegal, which is undo one of my words? Every single one of them said no. He did not want that. He had no intention of doing anything illegal. Okay, and he said that. He said no. They offered him, do you want this? He said no. That's illegal. I don't want you to take away the contempt. Okay, he's got a beef with Mr. Federico. He would probably love that.
He was making a joke. Illegal. It didn't go over well.
He said no, even without even knowing that 2 law enforcement officers were eavesdropping on that phone call. All right?
No, I see why they're making it. That's a valid entrapment argument, I would argue.
It wasn't illegal. He wasn't asking Mr. Federico to do anything in his capacity as a judge, like reverse a ruling, like lift a contempt order, vacate a fine assessment. Now, I know that the letters are addressed to him as a judge pro tem, but that's his title. Okay? Or certainly one of his titles, and he's showing him that respect. This is, in his mind, some type of legal negotiation, and he doesn't know that Federico is lying to him and working with the cops. He has because he's not intending to extort anything. Kim Blandino is not intending to extort anything. He has the right to file a complaint with the Nevada Commission on Judicial Discipline. Mr. Dyla even said so right here in the courtroom. So if he has a right to file a complaint, he also, you heard Mr. Detective Mead, he has a right to try and seek a meeting with Mr. Federico. And that's what he tried to do, okay? His appeal had just ended, okay, in March. And while that appeal's pending, it probably is improper to talk to Mr. Federico about it while the appeals are pending, especially if it might get reversed. Okay? It's, for example, it's improper for any of the jurors to talk to the judge or anything. Once the trial is over, that restriction's gone, and you're free to try and talk to any one of us. But not until that time, right? Well, he waited until his appeal was over, and then, again, he went to Mr. Federico's office. Okay? Sitting down and talking was all he ever wanted to do. So when this started on April 8th, like I said, he went to that law office because he felt that the Holy Spirit had directed him to do that.
That actually might be a valid
And
argument of entrapment if
He
that happens.
is. He's
and
a
they
deeply
were
religious man.
bargaining with him.
See that in some of his answers. And so he went there with nothing. The guy you see, anchor's boxes full of stuff. He just wants to try and meet with him. Like really, that's all. He's just trying to talk to him. See, read that and read that May 16th letter that he sends to the partners and see how many times he asks for a sit-down meeting. It's at least 3 times. He just, I believe, I want to sit down. That was really his only intention from the outset, is to sit down and talk to him. Okay? And it's not illegal to ask for that sit-down meeting. And really, this is a classic illustration of making a mountain out of a molehill. And his intent, again, is important because it's an element of the crime of extortion. You'll have your jury instructions, and it says it starts a person who, with the intent to extort or gain any money or property. He had no intention. Okay? In his mind, he's trying to just talk to him. So, hopefully, look, I'll say this. We talked about, Mr. Federico, sort of the art of negotiation, because he thinks when he talks to him, Mr. Federico, if you recall, was just like, I didn't like it that, he was getting one over on me, and just that sort of, the contempt that he sort of had for this process, but he led him to believe that he would, okay, give me something in writing, okay? When all he was asking for on that phone call was to sit down. So they changed it through the police. They changed it. They said, no. First they asked him, hey, don't you want us to, us. This was when Mr. Federico was on the call. Don't you want me to do this? Who's suggesting the crime here? Who's inducing it? Who's suggesting it? Who started that? His letter was to meet, was to talk. Again, he has every right to file that complaint, and he has every right to want to try and sit down and talk to Mr. Federico, even prior to filing. So that maybe his complaint is accurate. Maybe it's like, oh, okay, I can see that, and excludes that from the complaint. Mr. Federico obviously has no obligation to talk to him. But he didn't tell him, no, I'm not going to talk to you. And Mr. Federico, that's all Mr. Blandino, he sent these letters before, and that's all anyone ever says. No, I'm going to talk to you. And?
Seems facts on that, Your Honor.
And the jury will determine what the evidence is.
Thank you. So, he testified. No one had ever responded to him, ever. And that jury instruction number 13 talks about intent, okay? The specific intent needed for the crime. So be sure to review that and think about that here in the context of what he's asking for. What does he really, really want? He never asked for any money for himself. In the writing that they asked for, it was clear the money was the $25 was to go to someone else. He never asked Mr. Federico to do any official act as a judge. Okay? A public apology it's not an official judicial act. And judicial acts, when it's official acts, it's along the lines of the illegality that they proposed to him on the phone call, right? When they spoke to him, when they were trying to entrap him, right? When they were trying to induce him to say, yes, yeah, that's a great idea, right? Those elements, was his willingness? No, he wasn't willing to commit that crime, right? Now, the government is going to say, hey, that letter of May 9th, that he said, Mr. Federico, and the May 16th letter, they sent to the partners of Olson and Cannon and et cetera, and everybody. But look closely at that letter of the May, I guess it's dated May 8th, so on May 9th, that he sends in the request for a global negotiation. Okay. What may appear to you as just sort of a rambling stream of consciousness is really revealing in his intent. And his intent is not to extort, is to try and resolve a dispute. And I want you to look at that with me. Okay, this letter. This is Exhibit 7. You'll have it. Okay. It says, I do appreciate your phone call to me, at least to reach out and settle matters. I have been consistent in all my dealings to attempt to settle matters of dispute in all areas of my life and dealings, even when I have been at a Home Depot or retail or other retail establishment and have been treated badly by an employee. In that very moment, I ask the person for an apology. About 99% of the time, the matter is resolved then and there. With some, the person refused, and then I escalated the matter to the manager on duty to make a formal complaint. Okay, again, that might seem like some sort of rambling stream of consciousness, but it does show his intent. His intent is not any kind of extortion. It's to resolve a dispute, right? See, at this point, he doesn't know that he's being played for a chump by Federico and the police. He's a quite principled and consistent man. So in that letter, right, he says that when he seeks to reconcile, if he doesn't satisfaction, he goes up the ladder, so to speak. Right? My 12-year-old would call this action being a Karen. Right? Maybe you heard that term. It's not illegal to be a Karen. Okay. Mr. Blandino thinks he's dealing with someone who is sincere in trying to work things out with him. And remember how literally he takes everything okay? The first proposal didn't try and extort anything, they couldn't, they didn't arrest him for it. And he doesn't hear anything back from Mr. Federico. Like, nope, not gonna do, it doesn't say, no, I'm not doing that, I'm not doing any of that, right? No counter proposal, nothing. Like he said he would. So, yeah, he's telling partners, hey, be aware of the situation that's going on with one of your attorneys. He's being a Karen, right? That's what he's doing. Now, the May 16th letter that he sends to the partners, and you'll know that this is Exhibit 8. It doesn't, oops, it's not. This letter, it's a little awkward, it's that sort of lame attempt at comedy in this letter. It doesn't mention any crime at all. He's not threatening anything. He's just letting them know that he was contemplating filing a complaint with the commission as is his right. And it's a good time to remember that you heard from Paul Dylan. These are all confidential. They're not released to the public. Right? Only the most egregious cases get there. But like in the 4th paragraph, he said, I think it's one reason to have a sit-down conference. Okay? I'm here on the second page. I'm very flexible and willing to meet almost any time in any place with Mr. Federico. Okay? The last paragraph. I would hope Mr. Federico is encouraged to do a sit down. What he wants to sit down and talk and be heard. They changed it. Said, no, you have to give us something right. You have to tell us, you have to make this more than it is. That's your ticket in. Otherwise, I'm not going to engage. We're not gonna give you the time of day, right? Because again, he's a nobody. He's a nobody who everyone ignores. He's been doing this for years and has been ignored for years. Right, let's talk about the impersonation of an officer. It's really sort of piling on. You heard testimony. Investigator for the Dramatic Commission on Judicial Discipline doesn't really exist. You heard Mr. Dyla say they don't have investigators on the payroll of the commission, and any official investigation is done by independent contractors. But that's not until there's a long, drawn-out process, this tortured process of the complaint comes in and they review it, and then has to go to the 7 commissioners there, and they decide to act. So it takes a long process before it gets there. Mr. Federico knows this. He's been a judge for over 2 decades. He's been an attorney for over, 26 years, I believe.
And it seems facts not evidence as well as far as what Mr. Federico knows about this.
It's sustained.
So there's a long, drawn-out torture process. Right? Now, the government asked Mr. Dalla that when the commission brings these investigators on board, they become public officers. He said, I believe so, yes. Well, his belief is insufficient to meet beyond a reasonable doubt. The government will say, well, they can subpoena people, do all these things that they said on their closing. And that's just what Mr. Dyla explained. That's what they asked him right before that. And they asked, so they become public officers, right? And that's what he said, I believe so, yes. The closing argument here isn't evidence. Opening argument wasn't evidence. Only the exhibits admitted into evidence and the testimony of the witnesses here can be considered as evidence. And I submit to you, haven't heard definitive evidence than investigators for the commission or public officials. The belief isn't strong enough to meet the standard of beyond a reasonable doubt. And if that's the case, every element of every crime has to be beyond a reasonable doubt. You have to render a not guilty verdict. Regardless of that, let's say you think in your mind that they are private individuals, okay, with special authority. Kim never held himself out as such. In all his letters to Mr. Federico, why does he use the modifiers volunteer and unpaid? Especially if he's intending to defraud someone, to fool someone, right? It's a reasonable inference to draw that he's unofficial when he says that. But we get like willful denials from the witnesses on the government side. No, the words unpaid and volunteer would never mean unofficial, or come on. It's unreasonable not to even entertain the thought that those words could mean unofficial, right? If you're really trying to impersonate someone, why say that? Why not just say, I'm an investigator with the commission? See, one of the elements of the impersonation charge is defrauding or injuring someone. Okay. Marshall Marwitz I think you call it an investigator journalist, if I recall. That's not any public office. But he was never defrauded or duped into thinking that Kim was somehow officially with the commission. And regardless of whether he wasn't, if he wasn't fooled because Kim meant unofficial by saying unpaid, volunteer, he knew he wasn't connected. Come on. He wasn't injured. Mr. Federico, likewise, was never defrauded or injured by anything. He didn't lose his job. He's still a judge. Okay. Again, these modifying adjectives, unpaid, volunteer, mean unofficial. There's no intent to deceive anyone. In fact, it's demonstrative, really, of his intention to be honest about who he is. And I noticed Federico suggested, well, maybe he thought that Blandino was perhaps a rogue agent. Please. That doesn't really even pass the straight face test. You saw Mr. Federico first met Blandino in 2018 at that traffic trial. You watched the whole encounter twice. And while watching that at any time, did you think, hey, maybe this guy is a rogue agent? It just, like I said, doesn't really pass the straight face test. Okay, you have that in jury instruction 14 about what constitutes impersonation of a public officer. Okay, there has to be injury or defraudation, and we don't have that here. And okay, even if you are satisfied beyond a reasonable doubt that each and every element of extortion was proven, there is the defense of entrapment. That's like an exception to being guilty. He was entrapped by the police acting through their agent, Michael Federico. You have the jury instruction on entrapment. It's jury instruction 25. Okay. Entrapment consists of two elements. First, there's the opportunity to commit the crime. Okay, the first, it's called inducement, that the opportunity to commit the crime is presented by the state. And then second, the individual was not predisposed or willing to commit this crime prior to it being presented by the state. This is, and the state went over this, right? Some of the factors here. Now, this isn't an exhaustive list. Okay. Character of the defendant. Sure, he's a character.
He's enough of a spaz. They're probably
But
just not fighting
who
about
first
it.
suggested the criminal activity? Okay. I'll submit to you. the police did, through Michael Federico, said, hey, do you want us to do this illegal thing? Do you want us to, I keep saying us. You know, really, the phone call was from Federico, but, you know, they're all acting together. They're the ones that suggested it. You heard Detective Mead say, it's not illegal to go and ask to meet with someone. That'd be foolish. You don't really go to a big fancy law firm unannounced with no appointment and say, you know, can I do that? Can I see so-and-so? Okay. 3, whether the defendant engaged in the activity for profit. No. He didn't gain anything. He didn't ask for any personal gain for himself. Okay? $25 was reimbursement. There's a hold harmless clause, right? Federico discussed that. So Federico pays $25 to Mr. Blandino. Mr. Blandino then gives it to the person who loaned him the money. Well, that person, the loan of the money, can't go after Mr. Federico for that money because he's being held harmless. It shows he did not engage in any of these things for profit. That money clearly is not for him. $500 is for the Clark County Law Library. The class is for Mr. Federico's benefit. He clearly does. He doesn't think Mr. Federico, doesn't think much of him as a judge. Okay? And when the defendant demonstrated reluctance, he said no. All 4 people on that phone call, all were consistent saying, when we offered him to a crime or for him to agree to it, he said no. Right? Adopted Nancy Reagan's philosophy, right? Just say no. He said no. And they were trying to entrap him. Okay, his intention was always trying to meet him face to face and try and talk things out. He goes to a lawyer's office unannounced without an appointment to see if he had time to talk to him. He said, it's kind of foolish. It's not illegal. Again, Detective Mead said that. He had nothing prepared when he went. He truly went there with no agenda, just to try and talk to him. On the letter at the bottom, it says, I came here personally as a good faith gesture. Right? That's how he closes out that letter. Then the other elements come into play. The opportunity to commit the crime is presented, right? You know, so they're going to say, well, he went to the office twice, so everything started with him. The second letter on April 25th, he just wanted to meet, albeit with a new grievance for being kicked out of the courtroom. But that last paragraph on the April 25th letter begins, we should meet and see if these matters be settled. I mean, is that so terrible? He just wants to say, hey, can we talk about this? Can we work? You know? Can we just come to some agreement? But no. They said, no, we're not going to meet. Give us something we want. Give us something in writing, right? Why? So there could be a paper trail, so they could arrest him. They played him for a fool. They teased him, right? And led him on to think that they would negotiate with him fairly and in good faith, when really and truly nothing was further from the truth. Now, so his character, he does this all the time, right? Oh, he does this all the time. He sends these letters. Well, nothing ever come of it. You heard it. There's never any response. So finally he said, well, give us something in writing. And he talks about it. Hey, I've never done this before. Right? He's never, like a settlement. Like, so he cuts and copies and pastes the document. Again, he never created any such document before. They said, oh, he's got this pattern, this long history of doing this. No, when they said, hey, give us something in writing, trying to trap him, He's like, oh, okay, I'm, kind of out of his league. He doesn't, he's never done that before. Okay. Oh, I want you to think he's so scary, right? There's a survivability clause in there. He must be threatening Mr. Federico. You heard Detective Meade talk about they found nothing threatening or anything illegal in his house after they executed the search warrant. Okay? He's not a threatening person. They would have, I'm sure, they would have found something. They would have acted on it. Okay? He didn't arrest him after he sent that first proposal because he wasn't suggesting anything illegal. He wasn't predisposed. Okay, so even after they said, okay, give me writing, he's still not proposing anything that they act on because it's not good enough. He's not predisposed to commit extortion. So they ask him for another one, right? Another email saying, hey, give us a global settlement. Why? Because they're probably still hoping that he would ask Mr. Federico because they wanted to include that August 2018 trial. They're hoping, hey, undo that contempt. They're still trying to grasp at him requesting something illegal. But our quixotic friend here is not trying to enrich himself. There was never any criminal intent on his part. And absent a written document that the police requested, there would be no grounds for arrest and no criminal charges filed. So, he is, like I say, a nobody. I don't mean that in a mean sense. But he's a nobody trying to hold the somebodies accountable. I mean, a nameplate on the thing, it's not the end of the world. But yeah, we have, we discussed it. Our courtrooms are open. They're open to the public. And judges should be readily identified. Who is this person who's standing in judgment? We give judges a lot of power. And we should expect a lot. Okay? He's trying to hold somebody's accountable, but he gets contempt. Like, who are you? Who do you think you are? He is as sincere as our friend Don Quixote. His methods, are probably not what you or I would do if we were trying to accomplish the same thing. Okay? The rule of law is meant to protect the powerless from the powerful and hold them to account. Okay? The rule of law will survive Kim Blandino, but the rule of law will not survive the abuse of power against the powerless. So as you go back to deliberate, I'm asking you to please think about, what did he want? Look at those documents. All throughout there, he just wants an opportunity to be heard. He just wants to talk to him. He was the only one who ever gave him the time of day. And where there is no intent to extort, you must render a verdict of not guilty. There's no intent to impersonate a public officer. No one was defrauded. No one was injured. So I'd ask you, when you deliberate, to consider those facts. And I think once you do, you will come back with a not guilty verdict. And I appreciate you and your time and your patience. And remember, what was your number? It was a 10. Give it 10. Separate all your feelings, your negative feelings, and just look at the facts. I asked you on my opening. Think about this throughout this whole.
No, he's staying on point. I think he's doing a very good job.
What did Kim Blandino want? He wanted, you heard him, he wanted nothing for himself. He wanted to make the world a better place. Doing his part as really a relatively nobody. Thank you.
Thank you.
Oh,
This isn't to make the world a better place.
hang on.
This is so Kim Blandino can have fun. This is what he does for fun. You heard him himself. If you aren't having
Ooh,
fun,
he came out
you aren't
swinging.
doing it right. That's exactly what this is about. He told you he was having fun up here today, up here yesterday. He was having fun doing all of this because, as he told you, this is what he does. He goes, he targets judges for investigation, and then that's what's fun to him. He set up his office in his house where this is what he does, his illegal work, as he called it. This is not a matter of some man that's foolishly set off on some random journey against one judge. By his own words, what you've heard is what his course of conduct is and has been for years. He told you that, yeah, he sent these letters to other judges. Despite what defense counsel says, it's not true that he's never gotten a response. He told you himself that he got a response by marshals coming to his house. He knows what he was doing is wrong. He's not just Don Quixote. He's not even close to Don Quixote. He is a man who is obsessed with this cause. He is obsessed with this because this is his only form of enjoyment. This is what he enjoys most in life, is seeking these sort of interactions to see what kind of play he can get. If he can get somebody. Here, he thought he did. This, Mr. Blandino, if you aren't having fun, you aren't doing it right, that goes to his motive. You're instructed on motive. It's instruction 4. We're not required to prove motive, but it's something that you can consider. Motive is what prompts somebody to act. So, well, Mr. Blandino told you he doesn't really want much for money or anything like that. He doesn't really care about that, right? What he cares about is just going along this path and enjoying himself what he does. That is what he's accomplished here. That's what he's doing in every single letter. You can see it in his letters as he writes and he puts in these jokes that fall flat. This is him having fun, and that's why we're here. Because Mr. Blandino has decided that this is how he's decided he wants to have fun, is by going after judges, sending them inappropriate correspondence, having inappropriate contacts with them in an attempt to see if he can influence their actions, the actions of public officers. Jury instruction number 12. That's the definition of extortion. A person who, with the intent to extort or gain any money or other property. You're instructed as to what extort means. Extort is defined in jury instruction number 12. Extort means influencing another person's actions through withholding a disclosure of information. That's exactly what he was doing. He was influencing or seeking to influence, he had the intent to influence Mr. Federico's actions in his capacity as a pro tem judge. And he also, because this is an or, right, sought to gain money. Well, the money was not a large amount, right? $25 in his own pocket. Two different ways here that Mr. Blandino has met that first subsection of the first element of extortion, both by withholding information, right, and influencing action, as well as to gain money. $25. It can be 50 cents. It can be $2 million. It doesn't matter. It's going in his pocket, and that's what it is. It's going to him. And I'll just note, because defense counsel argued a lot that, well, this is going to repay somebody and the money's going here and there. It does not matter. That is not an element of the crime. It doesn't matter where the money was going. He said, you need to pay me $25. It doesn't matter what he was going to do with it afterwards. And then, across the whole thing, the next way that you get his intent is Mr. Blandino's intent to influence the actions of a public officer. I'll note for you that throughout every piece of correspondence that Mr. Blandino provided to Mr. Federico, it was addressing Mr. Federico in his capacity as a judge pro tem, in his official capacity. It begins right here. Exhibit 3, the note that he wrote on April 8th to Michael Federico, pro tem judge, alternate judge, City of Las Vegas. April 25th, 2019, Michael Federico, in his capacity as a judge pro tempore. When he finally tells him exactly what he wants, Michael Federico, alternate judge for Department 20, Courtroom 1C, Las Vegas Municipal Court, at the Regional Justice Center. The May 9th letter that he dated because he's been working on it for several days, May 8th, Michael Federico, in his capacity as a judge pro tempore. All of it, ladies and gentlemen, was directed at Mr. Federico in his capacity as a judge pro tempore, because everything that he sought to do was influence Mr. Federico's actions as a judge pro tempore, as a public officer. None of it is appropriate. It's illegal. That's the bottom line. Even if you buy what defense is saying, that you just want to sit down, though we'll go into that, and his own words belie that. If he says, Mr. Federico, I'm going to file complaints against you unless you sit down and talk to me, that's extortion, right? That is extortion. Defense went on and on about Detective Mead said, yeah, you can ask to meet with anybody. Yeah, sure. You can say, hey, look, I want to talk to you. I want to meet. But you cannot threaten somebody to do anything. This is not, as defense counsel said, a form of theft, as much as it is a form of coercion. This is a way that what the law has done here is made it illegal for people to say, I want you to do something, or else I'm going to do this other thing that you really don't want me to do. Because here, in this case, those things, imputing disgrace upon Michael Federico by filing a complaint with the Nevada Commission on Judicial Discipline, by sending all these things, these horrible allegations to his bosses, all of that, by filing criminal charges with the FBI, all of those impute disgrace. And that brings us to exactly what the threat was. Here he threatened, Mr. Blandino threatened to accuse Mr. Federico of a crime, namely a federal civil rights crime, and accusing him of that to the FBI, as well as to expose him to disgrace. Disgrace in being what he believed is an unethical judge who's violated the code and violated his rights, knowing, as his own words stated within the letter from May 9th, knowing exactly what this means. Look at that. Mr. Blandino says, when in the very few times that he actually speaks in the first person, I would want to know that a person who worked with the firm that had a prominent webpage was not bringing any disrepute in any way to the firm or its name. Mr. Blandino knows that that's what he's threatening, knows that's his whole intent here. To expose or impute disgrace upon Mr. Federico. You're instructed. Jury instruction number 21. Disgrace means to humiliate or cause loss of favor or standing. You heard from Mr. Federico what the effects of these actions could be and would be, and it was humiliating and could cause loss of standing and fame. In fact, when Mr. Blandino starts ramping up his behavior, right, when he doesn't get the response that he wants, and I'm not talking about the first response or the second response, I'm talking about the response on May 15, 2019. After that letter that he sent on May 9th, 2019, when he doesn't get a response back from Mr. Federico and he ramps it up to the next level, he makes good on his threat. He makes good on his threat to expose Mr. Federico to disgrace by actually sending everything that he already sent to the managing board of directors of his firm, all of his bosses. And what did Mr. Federico tell you about that? It was humiliating. It was humiliating. That's it. Mr. Blandino has committed extortion so many different ways in this case. Not just one. There's not just one avenue of extortion here. And it begins with Mr. Blandino. It begins right there in the note that he wrote on April 8th, 2019. I am ready to begin filing my complaints against you, indicating that it's for his courtroom activities, including violations of the code. He indicates that he's required by his religious beliefs and practices to give him an opportunity to negotiate a settlement. Please let me know within the next 10 days, indicating how serious he is, because he's been effective. He's been effective because his last two letters have resulted in letters of caution. So please don't take this matter lightly.
Dude's overselling this.
This note doesn't say, hey, I just want to sit down and I want an apology, Mr. Federico. It doesn't say that. It doesn't say, hey, I'm going to file a complaint against you
Prosecution doing
regardless
their
because I love
rebuttal,
an
but
apology.
this
doesn't
needs
say
to
that.
dial it back. This is not selling.
What it says is I'm going to file a complaint or we can negotiate. Extortion begins there. Then, when he doesn't hear anything from Mr. Federico, he goes to the Regional Justice Center. He told you that he was all around that day. He was all around. Yet somehow, he walks into the courtroom still carrying his tray of stuff with his shoes untied from walking through security. And he told you that before he ever got into that courtroom, he looked right into it and he could see Mr. Federico right there on the bench. Okay. Now, he goes in, he sits down, he gets kicked out. Mr. Federico, in no unclear terms, in his capacity as a judge in that moment, says, you need to leave because you came to my private law office. Don't stalk me. Defense and the defendant himself told you, if only he had said, just don't come back. I don't want to talk to you. That's it. Nothing like that. Then that would have been it. There are no clear terms. Get out of the courtroom. Don't stalk people. But what does Mr. Blandino do? Well, now he's getting the reaction he wants. Now, Mr. Blandino is having fun. And if you aren't having fun, you aren't doing it right. So now, Mr. Blandino knows he's on the right path. The path that he
This is
has
why
set
you say shit
for
that
the
sounds
fun
harmless. It can be used against
to
you.
see
Be
what
careful
he
what
can
you
get
say.
out of Mr. Federico. So he goes, he files a customer feedback complaint for whatever that's worth, and takes that and attaches it to a letter that he went home immediately and typed. April 25th, 2019, this letter. This is the letter that, once again, to Michael Federico in his his official capacity as a judge pro tempore, as we discussed. The subject line itself indicates what's occurring here. The subject line itself indicates, it might as well say subject, extortion. Desire not to have to file formal complaint with Nevada Commission on Judicial Discipline. That's not how this works. If a judge is does something unethical, they should just be reported. They should be reported. Anybody that's doing something unethical should just be reported.
Objection, that's an opinion.
Mr. Blandino, I should say, as a private citizen, anybody in this country
There's no duty to report.
doesn't have a right to dangle something over someone's head to say, you were unethical, now I own you?
You mean like a plea agreement? That's
You committed a crime?
illegal shit.
Now you have to do what I say? That is
That's like how an
extortion. That
indictment
is the
goes,
purpose of this
fucker.
crime. And in this particular letter, Mr. Blandino discusses thoroughly what he initially started talking about. In addition to identifying himself as a volunteer investigator for the Nevada Commission on Judicial Discipline, not helping the Nevada Commission on Judicial Discipline, he is for the Nevada Commission on Judicial Discipline, indicating, I came to your offices to see if we could resolve the complaint without having to use scarce judicial and Nevada Commission on Judicial Discipline
You think it's
resources.
wrong to hang things over people and make them do what you want.
He indicates that he's done so with other
I'm
misbehaving
pretty sure that's how
judges.
the indictment
And
process
then he
works.
goes on, so
Well,
to
plea
avoid
deals work from
having
his end.
the Nevada Commission on Judicial Discipline subject complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney
Just calling him out for being a
and
hypocrite.
I, if you wish to have an intermediary. You remember that whole argument defense counsel had about all Mr. Blandino wanting to do was to sit down with Mr. Federico? April 25th, 2019, he's telling Mr. Federico he doesn't even have to deal with him directly. He can have an intermediary. That's this whole sit-down thing, it's not even a real thing. Because you take a look at Mr. Blandino's words,
Is this
he
better?
didn't care. He wants to see what he can get out of Mr. Federico, whether it's Mr. Federico dealing with him directly or Mr. Federico's intermediary. And then, please know that I am very serious about following through to the best of strength that God gives me to do so. He indicates the sacrifice that I spend in time, inconvenience, and discomfort is very small compared to what they suffer to establish freedom and liberty based upon the very principles that God and His Son Jesus would wish for all on this planet to enjoy. The sacrifice that I spend in time, inconvenience, and discomfort, definitely putting himself out to be a martyr. But if you aren't doing it, if you aren't having fun, you aren't doing it right. Doing it because he's having fun. And then it goes further. In that April 25th, 2019 letter, it wasn't just about this.
I'm sorry, I gotta stop. It's not supposed to be like this. He's
No, I
trying
would
to
ask,
calm me.
stop.
He's trying to
Jim!
calm me.
Stop.
Blandino.
No, I would ask, can you invite Mr. Dickerson to not approach the defense table? I'm sorry.
Okay.
If he can
Hey,
stay.
He's trying to
Stop,
calm me, Judge,
stop talking.
purposely. He knows he's trying to calm me.
Stop.
This is
Mr.
improper,
Bell,
and I'm making a bar
lawyers
complaint
are
against you.
permitted
What?
to
I'm making a
walk
bar
around the
complaint
well.
against you, Mr. Dickerson. I will get these jobs, and I will make a bar complaint against you.
Mr.
Oh,
Blandino.
now you fucking idiot! You did the same
If
thing
I
again,
would
you
have done
dumbass.
this, you would have told me immediately not to do that.
Jesus.
Completely and totally inappropriate.
It's inappropriate for him to come here multiple times, and you know that, Judge.
He's in the well. He is permitted to walk around the well.
You would not let me do that if I were representing myself.
Stop.
If I were going over to the prosecutor,
I'm sorry. Look, I was just asking, Your Honor,
Okay,
you
we're
can be,
gonna
if he
take a
doesn't,
recess.
I-
During this recess,
I
you're
can
not
see.
not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication, or social media, read, watch, or listen to any news or media accounts or commentary about the case, do any research.
Howdy,
such
Mike.
as
Apparently you joined the
consulting
dumpster fire
dictionary,
just in
internet, or
time.
using reference materials, make any investigation, test theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or express the opinion regarding the case till it's finally submitted to you. We'll be in recess, and I'll also let you know when we're ready.
Thank you. All rights connecting to sure.
Oakley dokley. So what happened here? Well, I can sum it up very quickly and very succinctly. What happened? Well, pretty much this. This is what happened. Oh, is it not showing up? Oh.
and I had
He's
to
in
raise.
the
We're back.
well. He can walk around in the well if he wants to.
When I had
I'm
my,
not sure
when I had my
what-
asylum in the 1990s, I tried to walk around and Judge Moppin, he said, you can't walk around, you gotta stand at the table. And you wouldn't have, if I were representing myself, you would not allow me to go over to the prosecution table.
Woo-hoo.
I know that for a fact, and hearing your art, you ask if it's true,
Stop.
you say that's
pointing at
true.
me.
You know that's
Stop
true.
shouting at me.
I'm sorry. I'm a little bit heated, I
No, you're
apologize.
completely and totally out of control. It's not
No.
heated. It is completely and totally out of control.
Uh-oh.
Okay? I'd like to bring the jury back in so Mr. Dickerson can conclude his closing.
If he
Can
would,
you control yourself? Because if not, I'll just
I
remove you
will,
from
I
the
will,
courtroom.
I'm sorry, I apologize, but if he can agree not to come over here.
No, he doesn't have to agree with you about
He said he
anything.
would just a minute ago.
He doesn't have to agree with you about anything. If you can control yourself, you will be taken out of the
Okay,
courtroom
I
so that the
apologize.
prosecutor can conclude
I
with his
apologize.
closing.
I apologize.
Can
I'm
you
sorry.
control yourself?
Yes.
Basically, the prosecutor
Okay.
walked
You
to
know,
his
if I
table
just
and he's
may-
spurred out.
he's saying that I wouldn't make the objection. The third time he came over, he said, I don't know what he did, he was turning or whatever to Mr. Dickerson.
It does not help he threatened to report him as well.
I was
That's
going to
that's my
object or
point.
ask Your Honor,
Now you're doing
Yeah,
the same
not-
thing you threatened the judge with.
approach the defense table because he can't seem to control himself and he was turning. So I was not, and then he just started looking. So I was intending to ask Your Honor if he could not approach the defense table when this was,
I've never
whatever
seen
this was
I've
happening.
never seen anything like this. This is just completely and totally inappropriate. He's in the well. I mean, you can't control
Why wasn't I
yourself
told about that?
because the district attorney is walking around giving his closing argument.
Why is he getting that close to the table,
Like I
Judge?
said, if you cannot control yourself, you will be taken out of the courtroom so Mr. Dickerson can conclude. Do you understand what's gonna happen? You can't scream at people in the courtroom.
That's my normal
Well,
voice.
sometimes you can.
It's screaming.
I can't whisper,
Okay, that's a normal voice right there.
yeah, I'm kind of.
Okay, when you start screaming at people in the middle of the closing argument, it's totally inappropriate. You realize the jury just saw what you did?
I know they saw that.
That's not good for you. I'm just here to
I
tell
know
you,
that.
that is not good for you.
That's why he was taunting me.
So-
He wanted a reaction. He wanted a
So
reaction.
Mr.
and he got it.
Dickerson owns you? Okay,
No, he
so
wanted
his
to do it.
behavior dictates how you
That
behave.
was taunting.
Okay,
That was
he was
taunting.
not haunting you. That is ridiculous.
No, it's
Can
not.
you control yourself so I can bring the
Yes, I
jury
can.
back in?
I can.
Okay, have a seat.
Jesus Christ, not a cracker.
You can bring the jury back in.
Yes, and then threaten to report him. And, yeah, but I also think this guy's not afraid to play some mind games here with Blandino. So, wouldn't surprise me. There's a little bit of fucking gamesmanship going on.
Like, I'm not kidding. I will have you removed.
Oh, I know you're not kidding, Judge.
He can be removed from the courtroom. That has actually happened before. It happens all the time. Yes, can you? Apparently in Nevada, you're not allowed to scream at people in a courtroom. I thought this was America. Forgive me. No, don't fine him because then he's going to write her letters to take care of the fine. Don't do that. That'll just make things worse, Gabby. Given that's almost 7:30, we're gonna have dinner. I'll share dinner with you guys. So.
Gonna be a moment, man. There's two of them in the restaurant.
Okay, no problem.
Don't say anything.
Removing it's a nuclear option.
I apologize to the court again. He was taunting me and I fell for it. I guess he got what he wanted. He got what he wanted.
So what I was making the argument of was when the prosecutor said,
I know Mr.
well,
Peterson
he
very
said,
well.
oh, he was going to threaten us with something. You do what I want or I'll do something to you. I'm like,
And he got what he wanted.
How would
that's
you-
how the plea bargaining process works. That's how indictments work. So I just thought it was very hypocritical for him to say that's not fair. I'm having a sub from Penn
Judges see me
Station.
do so many closing arguments.
Yes, I
The
have.
same way. And against really violent people that have really hurt people and nobody has said that.
Also, I didn't know he had that big bald spot in the back of his head. That just looks oof with his hair done like that. Just adopt the Mr. Burns style, brother. You'll be better off. See, now that DA is like, well, nobody's going to remember my boring ass closing now.
Thank you, everyone. Please be seated.
Does the state stipulate to the premise of the jury panel?
We do, Your Honor. Thank you very much.
Mr. Bateman?
Yes, Your Honor.
Okay, Mr. Dickerson, you may continue.
You know he's going to refer to that.
Where did we leave off? April 25th, 2019 letter. This was, in addition, at this point in time, he writes, I believe you should seriously consider resigning. Not, I believe that we should sit down and have a talk. And I just want an apology. He goes on, we should meet and see if these matters can be settled for all concerned and for a multitude of reasons as cited in part above. Please know that you will be judged as you have judged. Right there too. The meeting is not about just a meeting. The meeting is coerced by the withholding of filing complaints, by the withholding of the disgrace that Mr. Blandino intends to impute upon Mr. Federico. And so that's April 25th, 2019. And he's already said all that. It's already become so clear that everything defense counsel said about, he just, wanted to sit down and talk, and he just wanted, he just wanted an apology. Well, by that point in time, when you're asking for an apology under a coercive threat, that's extortion. But we know that's not all he wanted. We know that Mr. Blandino wanted much more than just an apology, because on April 29th, 2019, when Mr. Federico called him and just said, "What's it going to take to get you out of my hair?" Mr. Blandino could have just said, "Oh man, I just wanted an apology," right? Though he's already committed extortion by this point in time. That's not what he said. When given the open-ended question of what's it going to take to get you out of my hair, Mr. Blandino says, at minimum, it's going to require an apology in a public forum. And the other things, I'm going to have to think about those. I'm going to have to take some time to think about it, and I'll get back to you. Because there were always other things. How far can he take this? Mr. Blandino, how far could you take it? Well, that's why we know. We look at this defense that Mr. Blandino has proffered, entrapment. This is an affirmative defense where he bears the burden of producing evidence of governmental instigation. The government hasn't instigated Mr. Blandino to do anything. All of his actions here today, his actions there on April 8th, 2019, on April 25th, 2019, on April 29th, 2019, on May 2nd and May 3rd, and May 16th, and May 9th, 2019. All of those were his own actions. Just as much as him jumping up in the courtroom today and yelling were his own actions.
I spilled water myself. I'm sorry.
And so we look at that. Defendant bears the burden of producing evidence of governmental instigation. They have not shown governmental instigation. Nonetheless, the only way that you even reach the other considerations under entrapment are if you find, yeah, it appears that Mr. Blandino has shown governmental instigation. Well, that doesn't exist. We'll still talk about the other part. So once Mr. Blandino puts forth evidence of governmental instigation, the state bears the burden of proving beyond a reasonable doubt that the defendant was predisposed to commit the crime. And then the law provides you a number of things that you can consider, but it's not everything, because you can consider literally everything that you've heard, all the evidence, everything that you know to be true, and everything that you can make a reasonable inference about, including the character of the defendant. Who first suggested the criminal activity? We just went through that. It was Mr. Blandino himself. Whether the defendant engaged in the activity for profit, well, he was getting $25, whether it was to pay a debt that he owed or to go into his pocket. Either way, yes, it was for his own profit. Whether the defendant demonstrated any reluctance, zero reluctance. Zero reluctance. Mr. Blandino never demonstrated any reluctance because Mr. Blandino did all of this deliberately. He set out on this path. He set out on this path because this is what he does. And that goes back to the first one, his character. What is Mr. Blandino's character? Mr. Blandino is a man who does this by his own admission, by his admission on the stand, by everything in his letters. This is what he does. And if you're not having fun, you aren't doing it right. That's the kind of character that Mr. Blandino is. And the nature of the government's inducement. Let's talk about that. The nature of the government's inducement was a call saying, what's it going to take to get you out of my hair? You heard. There was no offer to pay Mr. Blandino. There was no offer to do an apology in writing by a judge, acknowledging that Mr. Blandino has a right to go and view all courtroom proceedings anywhere he wants. There was no offer to have Mr. Federico, in his capacity as a pro tem judge, go take a judge class at the Judicial College in Reno. There was no offer for Mr. Federico to pay $500 to the Clark County Law Library. None of that. There was no inducement. The inducement, if they want to have anything to argue, is nothing more than a phone conversation. There was nothing more to offer there. This was all Mr. Blandino's own doing. And the most important factor, the law goes back, is whether the defendant demonstrated reluctance, which was overcome by the government's inducement. Again, that's the most important factor, and there was zero reluctance. How do we know that? Well, other than all the evidence, what did Mr. Blandino sound like on that call? Giddy is how it was described by witnesses, but by Mr. Blandino's own account of that call, he was happy and surprised. There's no one traffic here. So that call goes on. Mr. Blandino has the opportunity to think about what he wants, and he takes days drafting the document that he ultimately sends over on May 2nd, where he indicates, as you've seen over and over in this document, to Mr. Federico, right, in his capacity as a pro tem judge, what he wants is what we just talked about, what we've talked about this whole trial. $25 in his pocket, an apology in writing with an acknowledgement that he can go and view any of these courtroom proceedings, $500 to the Clark County Law Library, going up to Reno for several days to take a class, a judge class at your own expense. That is action by Mr. Federico in his capacity as a judge. So influencing the actions of a public officer is what Mr. Blandino set out to do. That's his intent the whole time. That's his intent with everything he does. When he contacts these judges, when he sends these letters, all he wants to do is influence the actions of judges. That is what his intent is. And by sending all of these correspondence to Mr. Federico in his capacity as a pro tem judge, his intent to do that with Mr. Federico is clear. This was not his intent to influence Mr. Federico in his capacity as a private civil lawyer, as a dad of 6 kids, as just some guy. No, he made it clear. His intent was to influence his actions as a judge. And point in case, beyond just what we see in all these documents, one of the things that he wanted him to do was go take a class for judges at the Judicial College. This is something that a judge does. That's it. He's influencing his actions in his capacity as a judge. That's what he intends to do. And what he's threatening to do is clearly not file the complaints with the Commission on Judicial Discipline. So, at this point in time, that's the only real threat, is not to file the complaints with the Commission on Judicial Discipline. But after that is when it starts to ramp up, right? Again, now Mr. Blandino is seeing that he's getting somewhere, or at least feels that way. And he was just starting to have fun. So let's play some more. and see what we can do. So he ramps it up. He ramps it up by responding to the email that Mr. Federico sent on May 9th with the letter that Mr. Blandino had been preparing for days, 2 days approximately. The letter of May 8th.
Oh my God, I want to
It's
kill
in
whoever's
this
typing on the keyboard.
letter of May 8th, where Mr. Blandino indicates, I spent a great deal of very valuable time preparing that document. I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23rd, 2019. I do appreciate the call, he says. I'm doing this more for people that follow me, he insists. Now, he goes on. He calls it in this letter what he's offering, Mr. Federico, what he's offering not to do. Not file those judicial complaints as something very serious, as he indicates it. Something very serious. And he then goes on, and this is where he ramps it up. In fact, you can be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 U.S.C. Section 242 for your actions on April 25th, 2019. So it wasn't until after he'd already sent his first iteration of what he wanted that he has to put on more pressure. And he has to say, well, obviously Mr. Federico's not getting the message, so I need to pressure him further. Up until this point in time, Mr. Blandino had not threatened to accuse Mr. Federico of a crime. But he goes on in this letter and decides, well, we got to do that because what else am I going to threaten him with at this point in time? What else is going to get him to act? What else is going to get him to engage with me? Because he says, I have already told you that if we cannot settle this matter, I'll file a complaint with the Nevada Commission on Judicial Discipline. But then he goes on, if we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench on April 25th, 2019, which he indicates is a violation of 18 U.S.C. 242, a civil rights violation in his mind. But that's not it. That's not all that he's now ramping it up to threaten. He's now adding in additional threats. Additionally, he indicates, I have come to realize you work with a partnership titled Olson, Canning, Gormley, and Gulo and Stabersky, that I should give notice to these individuals of the matters involved prior to filing with the Nevada Commission on Judicial Discipline or the FBI. And then he tells all of us exactly what he's thinking. The calculus is simple. Putting myself in place of any one of these partners and everything else equal, I would want to know that a person who worked with the firm and had a prominent web page was not bringing any disrepute in any way to the firm or its name. Because he indicates these issues could affect how the firm is viewed in the public. And then he goes on, therefore, consistent with my beliefs, I will send a copy of all the relevant documents to Olson, Canning, Gormley, and Gulo and Stabersky unless I hear from you by May 15th, 2019. Extortion again. Unless I hear from you, Mr. Federico, in your capacity as a pro tem judge, influencing the actions of a public officer, he will expose him to disgrace by sending all of this stuff to the partners of his firm. Well, we all know what happened. Mr. Blandino didn't get what he wanted. He didn't get what he wanted. He didn't get it the next day, and he didn't get it on May 15th. And so he made good on one of his threats when on May 16th, 2019, he sent that email with all the attachments, every single thing that had so far been sent to Mr. Federico to the partners of the firm. And in there, he pressures the partners of the firm to sit down with Mr. Federico so that these things don't become public, right? He says, I'll need a response within 1 week. He says, he also indicates there that since I gave Mr. Federico till May 23rd to settle before filing a complaint, I gave a deadline of May 15th to at least begin good faith negotiations, or I will notify the firm so that the firm has a heads up. If Mr. Federico failed to inform the firm of the situation, he might be required to do so. And I've attached all my prior submissions, he says, knowing that this would bring disrepute, that this would humiliate Mr. Federico, and so he did it. And the whole time, in his mind, he was doing it right because he was having fun. Mr. Blandino does not care what the law is. He does not care what he is allowed to do by law. He only cares what he can try to get other people to do, because that is fun for him. He wants to control my closing argument in this courtroom today. He wants to control Mr. Federico the same way.
I would object there because that wasn't
These are
necessarily
his
the case
actions.
for the jury.
All of them. None of this is government instigation. All of this is Kim Blandino. And because of that, ladies and gentlemen, because of everything that he did in this case, the multiple ways that he has committed extortion, we are asking you to find him guilty of but one count of extortion. Though there are several extortionate matters here, we only ask you to find him guilty of the one count that he's charged with, which encompasses everything. Further, it's clear. It's clear that he's been holding himself out as an investigator for the Nevada Commission on Judicial Discipline. He does that so that he could have an air of authority. The investigators for the Nevada Commission on Judicial Discipline, well, it was argued by defense counsel that they're not public officers. You have an instruction on that. Instruction number 17. It indicates by law they're required to have investigators. Further, that these investigators have the ability to compel evidence and compel witnesses. They have the authority to employ and contract with investigators. Nevada Commission on Judicial Discipline investigators have legal authority to compel by subpoena the attendance of witnesses and the production of evidence. Jury instruction number 15 tells you what a public officer is. Clearly, investigators for the Commission on Judicial Discipline are public officers. That's what he's pretending to be. They argued further as it goes to the impersonation of a public officer that Mr. Federico was not injured. Just because Mr. Blandino laughed at Mr. Federico's anguish, his worry, his concern, the concern for his family, the fact that he started carrying a firearm, the fact that he started worrying about his kids' bus routes, just because he laughs at that and he doesn't think it's something, it is. He's injured. That's the bottom line. And the action which he did to cause that injury was extortion. He's doing all of it under the guise of being an investigator for the Commission on Judicial Discipline. Somebody that could harm his career. That's it. He's guilty of that crime too. And so, ladies and gentlemen, you take a look at the evidence, you've seen it, what it mostly consists of are the defendant telling you exactly what he was doing. And we know he was trying to have fun. He was trying to have fun by influencing the actions of a public officer like he has so many times, and doing it by threat. So today, please show Mr. Blandino that this is not okay. This is illegal, and it's time to be held accountable. When you go back to that jury deliberation room, I ask you to come out and tell Mr. Blandino that he's guilty. Guilty of extortion and guilty of impersonation of a public officer. Thank you.
Okay, at this time, the clerk will swear the officer of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and you will return them into court when they have so agreed. So I'll help you go on.
Yes.
Okay, thank you. At this time, Ms. Melissa Zettino, you have been selected to be our alternate juror. So I am going to allow you to leave the courthouse if you want to. You will not be required to stay here during deliberations. However, I'm going to ask that you see Ms. Osborne.
We didn't hear, but I could have
before
sworn
you
she just
leave
said that
and
juror's
take
name,
charge of your
which
notebook,
is not the
your
way you
badge.
do
She's
that.
also gonna get
Jesus
your
Christ,
phone
Judge.
number. I just ask that you don't go further than 45 minutes.
Oh, yeah, I was going to say, it's
from the
late for you,
courthouse.
Matthew.
So
Holy
if we
shit.
need you to come back for whatever reason, we can get you back here in a timely manner. We will contact you and let you know either you have to come back or that you've been discharged as a juror.
Technically,
And I just want to remind you that you're still under the admonition not to discuss this case with anyone.
I think once you've left and discharged her, I don't think you have the authority to bring a juror back. I mean, really, under the law, I think your power is done if you discharge them.
And
Unless you
also
confine them to
we'll
the
take
building.
you back to go ahead and find your verdict.
Yeah, Mike, if you're leaving, have a night. Oh. So, yeah. That whole, when he kept putting up that whole argument of it's not, if you're not doing it, it's not fun if you're not doing it right. Maybe that was meant to be very harmless, and that was just meant for him, just something he believes in. But look how easy the prosecutor twisted that around and put that on the screen and just left it there the entire time he talked, showing why this guy does this to fuck with people.
Nice. You push my buttons.
That's why you have to be careful about what you say in court. It can be used against you. Those might be harmless words. It's just something to think about. Now, what happened in court? Well, there's an easy thing we can do. Basically, prosecutor's doing his thing, and the defendant kind of lost his shit, is pretty much the way to put it. I mean, really, here's what happened. That's pretty much what happened to, that's pretty much what happened, basically. Blandino lost his mind. So. But apparently he wasn't patient with himself and he lost his mind. And then he decided to act like a lunatic, and yeah, that carried consequences. The jury watched him lose his mind, and that's, they saw that. And the judge pointed that out, like, they just saw you lose your mind on this. So, yeah, that was really stupid of him, and I don't think that was a setup. I think the prosecutor's doing his thing, and Blandino's just a lunatic and lost his shit. I mean, that's what happened, guys. Trying to argue that there was some elaborate policy there, or I just think I think we all have autism at some point there, Mike, but he definitely just tried to show in front of the jury about being a lunatic. Now, what I will say is I have a big problem with those statements said outside the presence of the jury. He said, "Oh, he didn't want me near him. He's trying to manipulate me." I would have objected to that. I don't know how far that would have gone, but I would have tried to derail the prosecutor just a little bit. So, yeah, other than that, how are you guys doing today? She's like an Amazon. Holy cow. Also, Matt, why are you worried about her bending over? She doesn't really have much of a butt, it looks like. Oh, actually, I guess she does. You can't really tell because all the clothes are kind of washing it out. Yeah, well, that's the problem. When he said, "I'll report you to the bar in front of the jury," like I said, you can't do that. You literally just threatened him with the same shit you've alleged to have threatened somebody here with. That makes you look like a crazy man. The Micro Marine is actually looks like he's like one of the lead deputies. Oh my God, Blandino, do not fucking talk to him. God, Bateman, you need to tell him to go fucking get lost. Go the fuck away. Go the fuck away, Blandino. God, if I was Dickinson, I would not want him within 5 fucking feet of me. Jesus Christ. Blandino. God, but this just shows you how fucking insane this guy is. Damn, for real, she'd be looking down on me. She'd probably looking for guys who are like 6 something on Tinder.
The Kim Blandino thing, and as Liz D has pointed out, if the chair spins, Blandino wins.
Okay, well, I don't want to compete with another guy. I mean, while talking Mike, I watch his stuff once in a while, but I don't need to be competing with nobody right now. Just saying. I don't need to be competing with anybody when I'm trying to talk to about giving my commentary. What is Kim's tie? He's like wearing like an ascot almost. I don't really know for sure, but yeah, like Critter's right too. I think it's just an ascot. He's laughing like they're high school friends, yet in another minute he's losing his mind. No, I know, but if I'm talking and then he's talking, we're talking over each other. So that's the issue more than anything. Because then it just turns into a mess. No, they're not going to throw down. The cops would. The moment that guy raises his voice, he's probably getting tased at this point. So that's really it. There's nothing that's going to happen to him. So. Yeah, when he did that whole little freak out thing, yeah, I'm thinking that's it. Gosh, that's almost like out of a movie. I've never had a person react like that. I've already lost Critter to Peter Tragos. Oh, did she already move on? Oh well. Oh, well, she's here. Oh, they're not going to fall on him. He's just going to get tased. I guarantee you one of those guys is probably itching. Oh, I remember now what we're talking about with Peter Tragos. Yeah. Yeah, I can't let my locks grow like that. So, can you tell us how he's allowed to use a cell phone? I think part of that's just it's not worth the trouble to screw with him, so just let him do what he wants, if I had to guess. There's no real other reason why. I mean, really, that's it's not worth the trouble. It's not worth the fight. Just leave him be. Let him make a spectacle of himself. I mean, there's also, you notice at some point he's like, oh no, I spilled water on myself. Silly me. Okay, so what's streaming next? What we're gonna do next is going to be for the Clyde Daniels trials. We're gonna do Joe Clyde or Clyde Joe, the child who died. We're gonna do Dad's trial. We're gonna restream that because I was reading up on that a little bit this afternoon and I'm interested in it. We're gonna play that for a couple of days, and that should get us to next week when Mom's trial begins. So I think that's a good one to cover. Also, like I said before, next week at the beginning of the week, I'm completely going to be off the grid unless something breaks in the cases. So, yeah, Joe Clyde yeah. So, but we'll do Dad's case first and then get ready for Mom's trial. So, that's what I was thinking at least. But yeah, that was hooey. Yeah, I mean, I've had Moors and sovereign citizens make outbursts like that in court, so just never like that in a closing argument. Holy cow, that was weird. Very, very weird. J.C. Daniels trial for the new one. What? Huh? Yeah, we're gonna do his dad's trial first. We're gonna we'll restream that since it just happened, and then we'll do Mom's. Like we'll kind of line it up so it's like watching a movie marathon, then watching the. Yeah, I've got this. I'll keep the stream up. Um, I just didn't want to have all the noise talking over myself. But yeah, well, it's kind of like when new Star Wars movie come out, you watch all the old ones and then you catch up. That's all I was thinking of right there. I cannot imagine this is going to take forever and a day. Although it looks like I just ran me through an ad. Yeah, they're done too. Everybody's done. I guess we'll just have to keep our eyes open. But there's no wouldn't be as fun on appeal because it's just him harassing me over the phone and email. Dealing with him in real life would be a lot more fun. So you can be my entertainment director. That's perfect. So yeah, what else is there? Oh, so yeah, going back to that lady at the hospital in Vanderbilt, you know, Deronda Vaughn. Oh, I thought you said you will be. I was like, well, yeah, you're doing good. Deronda Vaught, yeah, she admitted she messed up, but there's no. Yeah, good night, Roxy. Um, there's no intent. I don't see how they get to the point of murder in her case or reckless homicide. So it's going to be very interesting because nobody wanted to do anything to her, not even the dead lady's family. They're like, okay, well, she was forgiven. So it's very interesting to see what's going to happen now in that one. Just like Dr. Husel, though, it's going to be a million medical witnesses probably. Oh.
Biological research facility.
Oh, sorry, guys. So, um, oh, you guys are welcome. I enjoy it. Uh, Rennie got sick. She's a little under the weather. She's fine. She'll be back. She's just not feeling well. We're gonna leave your DNA on the like button. Oh. Yeah. Yeah. Oh God, I'm sorry, guys. I did that with the mic open. My bad. My bad. Oh. Yeah, guys, I'm sorry with Dr. Husel. I thought it was going to be a good one. Well, for Kim, if he's found guilty, what do I expect for a sentence? I'm not sure. I wonder what this judge may do. I can see him doing jail time out of this. I mean, it's not a mandatory prison sentence. Oh, I will let her know. I know she'll appreciate that. Hope you got mic panties on. Yeah, I don't think he's going to prison or he's cracking rocks at the Nevada State Penitentiary, but somebody like him in jail is gonna have think about if he just goes to jail, he's gonna have a rough time. People like him get charged rent by other dudes on the tiers. Oh. Gosh, my sinus is just absolutely brutal today. Oh. Yeah, he becomes a prison attorney until they start losing, and then they probably start beating the shit out of him. So, yeah, that's the thing. If you're going to be the jailhouse lawyer, you better be good. It doesn't end well if you're not. Now, maybe he finds some wards and some other lunatics, and then, yeah, they can be friends. But I've already seen my fair share of jailhouse motions. Oof, they're bad. Sorry, I know I'm still on mute. Sorry, guys. Yeah. You guys have a nice night. Thanks for stopping by. You're leaving too, Gabby? Okay. Don't blame me, guys. Gosh, every time I'm always paranoid I've been doing that. So I guess it finally happened. There'll probably be some point where I do this for like an hour and I just talk to myself. Yeah, I don't know what's going to happen. I don't know what else is dragging on. So, God, I hope they come back. There's no point otherwise. So, yeah, I'm not really sure. Let me see here. Try to make sure I got judges up on my thing. Make sure we're ready. Yeah, I got Blandino ready to go. Just waiting and waiting and waiting. Well, guys, I mean, I don't know. I don't. I mean, it's 8:30. I mean, for a lot of people. I mean, where I'm at, it's 8:30. They should be coming back tonight, and it's only like 6:30 or so where they're at. So, yeah, if I get noted, I will. I'll probably hang out for probably another 20 minutes, but yeah, I mean, really, that's all they should do is just, yeah, exactly. Yeah, they just pick a 4-person, sign it. I mean, I don't think there's going to be a whole lot of discussion on this. So, like I said, I'll stick around for a little bit, but I probably will bounce coming up. And if you guys want to go watch it on our Nevada judges, I would not be offended if they beat me to the punch. So, yeah, that's really it for right now, guys. That's kind of where we are. Yeah, guys, sorry. I know it's a lot of dead air just now. You know, oh, the judge sent the jury home? Oh my god. I thought she sent them out to do their work. Okay, well, if that's it, then yeah, we're done. Yeah, if they're going home, if they've gone home, that's it. If they get gone, then they're gone. So yeah, if that's it, guys, then yeah, we're done for the night. So yeah, that's it then. Looks like yeah, they're done. Dunsky. Let me just double check. Yeah, that's it, guys. Yeah, it looks like it's it. So thanks, Don, for bringing that up because I would have been here for a while. Appreciate the heads up on that. And yeah, we'll talk later tomorrow, guys. So have a nice night. And tomorrow morning, Joe, Clyde, we'll start that trial up and we'll start running them from there. I'll start up at 9 a.m. You guys have a nice night.